Okay.
All right. Good morning, everybody. Good morning. Good morning. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the entity that is offering this class for CE credit. CE credits with these virtual classes do take us approximately 3 to 5 business days to record. So they will be recorded then. And please, we need to know that you are there and interacting with us, not just that you have turned on your computer and have walked away, but how could you with this class with Amy teaching? So please type in your name, your email address, your real estate license number. Make sure in the chat box when it says to everyone. That way it'll go to everyone. And we keep the log of that as well as a log of when you are in and out. Also, if you have a camera, please turn on your camera so we can see your interaction. Please ask questions through the chat. Amy and I will be monitoring the chat so that we can answer your questions. I am hopefully recording this. Sometimes we are having technical difficulties. So I am just going to this course. I'm going to read the notice to students, and then I will hand it over to Amy. So Amy, give me 1 second. Let me go through the notice.
No worries. Thank you.
All right. All right. Oh, shoot. Here we go. Notice to students for the virtual broadcast of a CE class, GREC approved classroom class. The Georgia Real Estate Academy, with the end date of renewal being December 31st, 2022, presents to you the following course of study. Pitfalls in Writing Special Stipulations. It is GREC Georgia Real Estate course number 67868. It is a virtual remote broadcast of an approved in-class course, 3 hours in duration, and approved by the Georgia Real Estate Commission for continuing education. No prerequisites. The instructor is Amy Davis, named partner and closing attorney of Davis and Associates Attorneys at Law, LLC. There is no homework and no written exam. You must be on time and present for all remote virtual broadcast instruction hours in order to receive credit for the course. Roll call and documentation of your real estate license number and your interaction will be conducted via the chat function at the beginning of each session, after all breaks, and also one more time before you leave. Students may only receive credit for a specific course number once every 12 months. If you have already received credit for this course within the last 12 months, you are of course more than welcome to stay for the information, but you will not get additional CE credits. There is no recruiting for employment opportunities for any real estate brokerage firm in the class or on school premises, loosely defined in these virtual classes. Report promptly any effort to recruit to myself, Dana Sparks, the director of the Georgia Real Estate Academy. Heidi Kelly is the coordinator of the school, or to GREC directly. So I am going to stop my share. We again are so excited. Amy Davis is the instructor, and Amy, I am going to pass the host duties over to you. Take it away, Amy.
Okay, thank you. Okay, everyone, I apologize. I was trying to get registered and it was not letting me register, or not letting me in. So sometimes getting through to this. If you have a video, she's already told you, you need to have it on. If you don't have a video throughout this process and throughout this seminar, you're going to need to constantly check in, just ever so often check in on the chat. Re-put your name, your ID number, license number, and your email on there if you want to. Ask a question, however you want to do that. If you have not, I'm looking here, all of you may not be here for CE credit, and that is fine. I love it when people just want to learn new things. But if you have not put your information on there, I need your name, your license number, and your email address in there. It looks like I have more people on here than what's actually on my chat link. You're going to have to do that a couple of times today, just so that you know. You'll have to do that when you log back in after the break. You'll also have to do that at the end of the class session, to just show that you were here the full time, show that you were a part of this. I'll go ahead and tell you, I am losing my voice. So today's going to be a fun day. My daughter plays basketball, and as any competitive parent, you know, you're out there cheering your daughter on, and she had tournaments all weekend and then yesterday too. So let me just go ahead and start just telling you, for those of you that don't know me, I'm Amy Davis. I have been doing real estate law now. This is going into my 21st year of doing this. Yes, I started when I was 12. But I've been doing this a very long time. The biggest issue that I truly see in real estate is the writing of special stipulations. And with what you do, it's really coming into writing the special stipulations, writing them clearly. I often say that I feel like I'm trying to decipher hieroglyphics in this world that I work in, because a lot of times I get special stipulations on contracts that are really able to be, determined that they could go one of several different ways, or in the alternative, I can't understand at all what the intent is. So today, my goal is to help you write a more clear, more concise, more well-written special stipulation when you have to do it. I will go ahead and preface this by saying, if it is something extremely specific outside of your vast knowledge or wheelhouse of something that you normally work with, I'm going to go ahead and recommend that you contact either your broker or your mentor, or your support group within your organization for your real estate brokerage, or possibly your closing attorney, whomever you use, whoever you feel most comfortable calling. That's what I recommend that you do. There's just too much risk at getting us something wrong. And as I heard yesterday from Dana, a poorly written contract is worse than having no contract at all. And it really is, because of the legal ramifications of what happens when you write something poorly. So I am going to go ahead and send you, oh, she just did it. Okay, so you've already sent my information out there. Great. So I'm going to go ahead and go, and I'm going to put everything on here for you, so you will be able to see it on the screen. The first part of this is really going through step by step how to write a special stipulation, what stipulations we feel are good stipulations, what stipulations we feel are just very poorly written. There is a lot that goes into writing special stipulations. In Georgia, realtors cross the line and walk the line of practicing law without a license, I think, more than just about any other occupation out there. For your edification and your knowledge, most states do not allow realtors to write special stipulations for contracts at all. So if you were practicing as a realtor in many other states, you would not be allowed to even write the special stipulation. It would be required to go back to either the closing attorney or to the attorney representing whichever party needed the special stipulation written. So I would be very cautious to say to you to be careful about what you're writing. You are the professional. So when something goes awry, who are they going to blame? You. They're going to blame you. And when I have to get into a situation where I'm not sure what something says, we will call you and we will say, we don't know what your intent is here. So let's start out with a couple of examples of what we are looking at. Give me just 1 second to start my screen. So I'm going to minimize some things and then open up some other things. So give me just a second to do that. And then I will get this going for you. Let's see here. Bear with me. It's just a matter of getting everything open. It's so funny how all this works now, isn't it? Let's see here. Okay. Well, I've got too many. Sorry, Dana, give me 1 second. It's opening. It's just taking a second today.
Amy, before you hopped on, I was just telling everyone how technology is awesome when it works.
When it works, it is fantastic. When it gives us a hiccup, it's not at all. So there are days when I want it to work really, really well and it doesn't. And then there are days when it doesn't do what I want it to do at all, but we are getting there. So let's just minimize that one. Okay. I get tickled sometimes because there are opportunities or things when I am working on something at home and my children will say, let me look at it, which is always fun, right? They certainly make you feel less than capable at times. And given that one of them is 9, it's a little scary, honestly.
All right, we can see your screen now.
You can? Okay, good. Perfect. Okay, let's go on up. Let's see if I can get back up here. Okay, so we're going to start right here at the very beginning. One of the big issues that I am seeing with a lot of what we are talking about right now is the need for, and I'm going to minimize this just a little bit, is a need for us to be able to determine what we are actually trying to say, whether it is a specific issue, whether it's a technical issue, whether it's an ordinary meaning. I had one yesterday that came across my desk, and the special stipulation says that the seller is to replace all areas of barren ground with grass. Okay. I have no idea what that really means. What grass? Where? How much is to be replaced? What type of grass? When is it supposed to be done by? What is the cost? Is there a cap on what the seller is going to pay? Or are they supposed to just do all of it? And who's to approve it? And what happens if they don't? So I don't know how relevant that special stipulation is to what I am working on, or how relevant that special stipulation or how important that special stipulation is to my contract. Because what we've just said is the seller's going to do something, but we don't know how much of that something they're going to do and exactly what that something is. So that something could be they're going to put in what type of grass. So that's the first determination. That something could be they're just going to put in whatever the cheapest grass available at this time is. Is that going to be the same grass that's the other grass? Are they going to put grass that stays green most of the year? Or are they going to put grass that hibernates, what's already down there? I don't know what they're doing. So one of the big issues that I have right now is not using ordinary words or using ordinary words in place of technical terms. So we're going to go through a couple of these technical terms and see what you think is technical and what you feel is actually an ordinary term. And I don't know why this keeps hopping back. I apologize. It keeps going back and back. Okay, so one of the ones that I see often is hardwood floors. My sellers are to do something with hardwood floors. Let's say that the requirement for this example is that they're going to have the scratches in the hardwood floors sealed, or they're going to have them do some work on them just to make sure that they're not as noticeable, which can now be done instead of having to stand down and redo everything. I don't know what you're really talking about when you're talking about hardwood floors in a lot of these situations, because we have come so far forward in the last 20 years with what we call hardwood floors and what we also call synthetics. Or are we talking real wood? Are we talking pressboard? What are we talking here? What are we doing here? So I'm going to go ahead and tell you, just as an example, this one is just an ordinary term. One of the biggest mistakes I've ever seen made was we had a seller who held over a property after closing, and they had hand cut floors. They were hand sawed. All the marks in them were hand done. Everything was hand done. This is not a situation for those floors that you could just legitimately go in, sand them down, and restain every floor in every room of that house. This is a situation where the poly on the top has to be hand removed in most of the cases to fix the scratches that were left. What transpired was our sellers movers went to move the property, went to move everything out of the house, and it looked like they literally just took the dollies and ran them across the floor, because there were these very, very consistently, even width scratches all over the floors when the buyers went to do their walkthrough. And they had written a special stipulation that they were to have all hardwoods sealed, the poly removed, sanded, and sealed. Well, when you do that, you take away the finish of the hand work that was done on the original floors in there. So when we saw the special stipulation, we immediately alerted them, this could be a problem. Let's get this fixed on the front end, because I don't think this is what you're intending for it to be. So you need to be very technical in the terminology that you're going to use. If they are going to have to replace certain pieces, you need to know the type of wood that is down. So you need to get a flooring company to come out and look at it and confirm the type of wood, whether it's red oak, whether it's yellow oak, whatever it is. Whatever that color is, you want to use the same thing. Otherwise, your flooring is going to be different. What about coring countertops? Do you guys think that is a technical term, or do you think it's an ordinary term? What would you say that was?
Technical.
It is technical. It is a technical term. Now, there are now different types of Corian countertops. So I'm learning, as you guys are learning, about all the new things that are out there. If you're going to do a specific type of Corian countertop, I would recommend that if you could please put in exactly what your intention is, that would be great. And I'm going to tell you, there's a whole lot of issue with the Corian, the granite. If you know the type of Corian countertop it is and there's a repair, you need to say it's got to be this design. Remember, with some types of countertops, they can match them really easily. Other types, each slab is going to look different. So you need to figure that out on the front end. My recommendation when you have these issues come up, we had one where they had a cracked granite countertop on a bathroom sink. It wasn't very large. And my recommendation was, I don't think you're going to be able to fix that, because you're going to have to try to replace it with a piece that matches. And that's very difficult to do. So we recommended that they go ahead and just replace the whole countertop. I know that's costing the seller money, but I can assure you the buyer isn't going to be happy with it if it's done the other way. What if I said it was marbled, a marble countertop? Would that be a technical or ordinary term? The difference here is that marble versus cultured marble or any other kind of marble is, when you're talking just regular marble, it encompasses a whole broad band of different types of marble top that may be out there, versus if we said, it's to be replaced with a similar, with the same color scheme, cultured marble, so that that you're getting the right thing. I would also caution you on a couple of different things. One, with Corian, granite, and marble, there's different thickness to each of those countertops. I would recommend that you put the type of thickness that you want on those countertops, or that your buyer wants, not you, but your buyer wants on those countertops, because it can make a very, very big difference as to how smooth the surface ends up being when they cut it and sand it down and polish it, as well as the durability of it. So I would be very cautious in, advising your client, is there a certain thickness that you want? You may want to do a little research so we can do this amendment. Hardy plank siding, is that a technical term, ordinary, or scientific? What are y'all saying? I want to see what you're saying here. Okay, hardy plank would be a technical term. Just be aware that if you know that there are multiple issues going on, or multiple types of siding that they can do, give as much specific information. Hardy plank siding, whatever thickness, whatever, whatever you need to add on there that would give you as very specific information. Architectural shingles, is that technical or is that ordinary?
Ordinary?
Okay, so it's actually technical, but here's the thing with shingles. I need you to list the color that you want. and where you're getting that color from. There are different colors based on different roofing companies use different types of shingles. When you're looking at it, it'll tell you the brand of the shingle at the top usually and the color. I want you to write both of those on there. Make sure that you do that as quickly as possible, because if you know that there's something going on with a roof and you know there's some shingles that need to be replaced, after the storm we just had come through, a number of our neighbors had, a number of shingles that were pulled up off their home. So I would strongly encourage you to have a roofing company come out and let the buyer go ahead and pick the color, whatever, and meet them out there and make sure that it matches or try to match it. Stainless steel appliance, is that technical or ordinary? This one's sort of a trick question. It may not be what you think it is. Yes. Stainless steel appliances are actually ordinary terms. It's like saying I want a white refrigerator or a stainless steel. There's nothing technical about a stainless steel appliance. If you guys are not actually answering questions or not talking, if you will turn your computer on mute, that would be great. Let's see here if I can do it. When you're answering, if you'll turn it off mute, that's fine. But if you are not answering, go ahead and turn it on mute. But stainless steel appliances are really an ordinary term. If you want to be very technical about it, you can put the type of refrigerator it is. I'm going to go ahead and tell you that if you are leaving a refrigerator, it does not hurt. And in fact, it actually helps because we've had several sneaky sellers, as I like to call them. I'm going to give you two pieces of advice, and we laugh about this, but it actually is proven to be true in a lot of instances, not always. The very first piece of advice I was told by one of my paralegals that I very first worked with when I very first started real estate, she said, I'm going to give you three pieces of advice to remember. The first thing she told me was that buyers are liars. They will tell you they can afford something that they can't. They will tell you they have no debt when they do. They will tell you that they've already been pre-approved when they haven't. I would take everything with a grain of salt that you're told. Not all buyers are liars, but it does present an interesting dynamic when you're talking to them. The other one is that sellers are sneaky. So we call lying buyers and sneaky sellers. And the reason that she said that was, she said, I have seen in my 20 plus years at that time of doing this, the number of sellers that have agreed to something in a contract who suddenly want to get out of doing that after they've put it in a contract to agree to. So if you have a seller who is leaving the refrigerator, even if it is in the seller disclosure, I'm going to recommend to you that you write down the serial number and information off of it and put it in the contract that they are leaving it and it's to be left, and it's whatever brand it is. We have had two instances, and I don't know why this is happening so much. We've had two instances where stainless steel refrigerators that were in the kitchen at the time of the contract were replaced with lower quality, lesser name brand stainless steel refrigerators, even though they were supposed to leave what was there. The problem was my realtor nor my buyer could prove what was actually there because the picture for the kitchen doesn't have the name on it, and they didn't have any proof of what was there. The reason that they knew it had been changed out so easily was because it was much smaller than the one that was actually encased in the framing of where the refrigerator was supposed to go. So I would be cautious of that. What about Berber carpet? Is it a technical term or is it a scientific term? Let me see what you're saying down here. Ordinary. Are y'all saying ordinary? It's actually a technical term. Berber carpet is a technical term because it is the way in which it is made and threaded through the flat piece that they thread the carpet through. So it's a very particular way in which they do that. Low E glass. Does anybody know what low E glass is? Do y'all know what low E glass is? Okay, so would you think this is technical or scientific? The picture on Okay, so the picture on MLS did not show the type of refrigerator it was. It was kind of blurry where the refrigerator was. You couldn't see the name brand on it, and you couldn't tell what you really couldn't tell what the name brand was. You could only see that it filled out the area, but you could not see anything beyond that. So sometimes the pictures in the kitchen aren't able to be zoomed in to that degree because they're filtered and they're made to look really, really, really pretty and shiny. Low E glass is a scientific term. It is the way in which the glass is manufactured. It's a little bit more scientific. It's a little bit more than technical. So low E glass would be something, if you're replacing windows, that you would want to use a scientific term. The one thing I'm going to caution you on all of this right now, though, is this. Every single thing, every single one of these things that I've laid out for you are things that you need to have this plus something. Architectural shingles that are made by X, the color of blank. Stainless steel appliances being an LG refrigerator with SKU number, blah, 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 as found at Home Depot, or the LG refrigerator located in the home, which has a serial number of da, 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 da. So, and that's on the inside. Usually most people don't take out that little sticker thing that's on the inside. You can do that as well. I would just strongly encourage you that whenever possible, for certain things that are often things that get removed when they're not supposed to, that you be very specific about those things. We typically don't have anyone remove a water heater, so that would not be the same as we have had a lot of people that were supposed to leave a refrigerator, remove it, even though they were supposed to leave it. Same thing with window drapes. If your client wants something to stay and you're doing it as a special stipulation, I'm going to go ahead and tell you that you need to make sure that if you're doing it as a special stipulation, that you write out what it is. So, and then that way you do it. I would also, where draperies are concerned, take video and pictures of those so that you know what they are, or have your client do that when you're doing, your contract. If they say, look, we want to do the contract and we want to get, we want to ask for these draperies, are they going to stay? Go ahead and have them take a picture of them so they know exactly where all the draperies are. It doesn't help the video. Now, you will have some people who tell you that video and all that is prohibited. You may need to ask the listing agent if they can take a picture of the curtains that, because they want them to be left. And they're going to ask for those, and just ask. It doesn't hurt to ask, or immediately after going under contract, possibly, when you go back in, because a lot of people are now asking to go back in to measure, maybe do that. So I'm just giving you some of this information because these are the ones that we see most often with issues. I do not know what the issue is with repairs right now, but we have a lot of sellers who are agreeing to do repairs on properties and then come into closing, or the buyer's going through the walkthrough and finding out that the repairs are not done. We are going to address some of that today. I'll give you a couple of special stipulations you can use. We just had one on the septic tank. They were supposed to have the septic tank cleaned out and field lines checked. And that was not done when they got to closing. So we'll talk about some of the ways that you can handle those issues and verify that before you ever get to the closing table, because we don't want to have it happen at our table. Not just because I don't like when things go awry at the closing, but everything else could have went perfectly well until you got to the point of, being right there with us for the closing part of this. So I don't want you to have issues at the very last minute because of something that the seller failed to do. So we want to try to stave that off as best we can. Now, there are times that you're going to find, no matter how well you write a special stipulation and try to protect your client, the sellers are still not going to do what they're supposed to do. And that happens also. So we'll try to show you some of that. I'm trying to see. I was trying to get rid of this, but it won't let me do it for some reason. But okay, so let's talk about giving the interpretation of the contract that will best support the contract, not defeating it. We have a lot of special stipulations that are written in mind with the buyer being able to terminate. Keep in mind that your goal is to get them to the table. Your goal is to get them in this house because this is the house they want. And also keeping in mind that when buyers put a contract on the home, it is officially emotional and not business. And that is true for about 95% of all transactions that I see. I rarely have somebody say, you know what? I don't need this house. I don't care if I get this house or not. If you're not going to do what you say, I'm not going to buy it. It doesn't happen that often. What happens is the buyers typically start panicking, saying, I really want this house. This is the house that I want. We've put 4 offers in. We got beat out of all these offers and we really want this house. And then they settle for a situation instead of pursuing it, simply because they just want to make sure that they get the home. So I want you to make sure that you're writing special stipulations to make sure that it is written so that the contract can push forward. In general theory under Georgia, the rule is that if the buyers did not intend for, or if the buyers intended for something to happen, that it would be written clear and concise, and have a repercussion for failure to do so. A lot of people forget or either don't know that just because a particular piece of the contract was not done by the seller, that doesn't necessarily mean that the buyer can just walk away. The buyer still has a duty to perform in most of these cases. So if I have a special stipulation that says that the seller is to have the gutters cleaned out by XYZ date, with vendor of, seller's choosing, and they don't do it, my buyer cannot just walk away from the closing because they didn't do it. And this may be surprising to some of you, but just because one action by one party isn't complete does not mean that the entire contract is void or that the entire contract can be terminated. It still may mean, depending on how it was written, that the buyer has to fulfill the obligation of purchase. And keep in mind also that there are only a handful of things, 5, I believe it is, that can survive, that automatically survive closing in your contracts. So let's talk about a couple of these things. Georgia law obviously favors the interpretation of the contract and agreement that upholds the parties having to move forward with it. They prefer, the state courts and the Supreme Court of Georgia prefers not to rule in favor of interpretations that render contracts void, meaningless, or unenforceable. So when they're looking at the particular meaning of something, they're going to be looking at how important was this to completing the contract. And if you just said seller was to buy a home warranty and then seller refuses to buy a home warranty, but all these other terms and provisions are completely enforceable, your buyer is most likely not going to be able to walk away from that contract because seller refused to buy a home warranty. And we're going to talk about some more of this. So look at the entire contract to determine the meaning of a particular provision in a contract. And what this means is that when the state court looks at this, or when a court in the state of Georgia looks at this, although Superior Court, although one provision in a contract may be extremely important to that document, if the meaning of the provision cannot readily be determined from that provision alone, it is acceptable to review the entire contract to gain a better sense of the meaning between the parties. Looking at the entire agreement may well lead to an enforceable contract and therefore a closing rather than termination and release of an agreement. So I often see realtors write a special stipulation that is actually 3 or 4 special stipulations that they've separated out. So there are times when I have to look at a contract and say, okay, I'm not really sure what the intent of this particular sentence is. But if I look at, on number 1, but if I look at 2, 3, and 4, I can tell that there's a lot of work that needs to be done to this, and that the intention is that this is to be, for example, someone who is licensed in that area to do the business. So let's say that you have a clause that says repair work is to be done on a plumbing item. But that special stipulation alone does not say that you're supposed to have a licensed plumber. But number 4 says that all the work to be completed as part of the completion of repairs is to be done by those licensed in the area in which the field is to be completed, such as a licensed plumber, electrician, or electrician to complete plumbing or electrical work. So that is the sort of most simplistic form of looking at what the terms of the contract are. If there was something pre-printed in the contract that automatically said it had to be completed by a licensed person, then that would also be looked at, even if you only said that the repair work was to have that plumbing item done. So we do look at other parts of the contract. We are what's called a 4 corners state. And by that, what I mean is that we look at the 4 corners of the contract and everything in there to determine what the contract intent and meaning is. And if we can figure it out through that, we won't look at anything else unless there is, typically it takes some act or action or fraud to get the courts to look at something outside of it. For example, we induced someone to sign a contract, but then intentionally left something out. This is an allegation that often happens when you have one unrepresented party. So be careful with that. People like to not take accountability for their actions, or lack thereof their actions. And the biggest excuse I hear in real estate is my realtor didn't tell me. That doesn't hold water with me, because when I get these calls of complaints on realtors, I often have people call me because I have a realtor who likes and respects me and wants to do business with me, and they get a complaint from somebody and they say, well, call Amy and let her, look through it and see if there's an issue, see if you have a valid right to file a complaint with the GREC, etc. And the very first thing that I ask people that I go through with them is, I need you to not take offense about what I'm going to ask you, but I need to know, because I need to know what I'm dealing with. Number one, did you read the contract? How many of you can honestly say that you think that your clients are reading the contracts? Because I can tell you they're not. And I can also tell you that they're relying on you to tell them every word of that 8-page document. And it would take you a good hour to sit down with a layperson who is not in this industry just to kind of summarize what it means and answer their questions probably. And I doubt many of you in the industry are doing that regularly. So let's talk about what that means for you. Is they call me, and then my next question is, okay, if you didn't read it, again, don't take offense to this question, but I need to know, are you literate? Because if someone cannot read, then that's a completely different conversation than someone who can read and failed to do so. I will tell you, I've only had, in the 20 years I've done this and 20 years I've had to ask that question, I've only had one person tell me that they could not read and that they had informed the realtor that they were illiterate and needed to have the contract read to them. And things were not done completely as they should have been done. If you have someone who ever tells you that they cannot read or cannot understand it, I would immediately advise you to get your closing attorney or your broker involved, just to make sure that they understand everything that you're saying to them, or you also have a witness that you have tried to make sure that they do understand. Let's talk about handwritten or typed words prevail over pre-printed words. So if I take the GAR contract.
Can I ask a question? And I don't know if you want to answer it now or a little bit later. How does the fact that the provision of within the four corners of the contract reconcile to not a party necessarily having termination rights should the other party not perform?
I'm sorry, I missed part of that.
How does it reconcile with the Georgia provision of within the four corners of the contract reconcile with not necessarily having termination rights should the other party not perform?
Right. Okay. So when we're looking at the four corners of the contract, what we're looking at is what are the provisions that have been written in. And so to make this very simplistic, I'm going to give you an example. If you write in, seller is to clean out gutters. And what we are looking at is in the GAR contract, there actually is a clause in there, and it is in almost every well-written contract, that if the court deems one part of the contract unenforceable or voidable, then the rest of the contract, wherever permissible, can be upheld. So what that means is they're going to look at whatever it takes to try to make sure that the contract is enforceable and that it can be done without that one piece in it, that one piece is not necessarily material to the contract. Just because you write something in does not make it germane or material to the contract. It just means it is one of many things that you all have to do and perform to do everything by the letter of the contract. So just because a seller says, I'm not going to have the gutters cleaned, doesn't mean the buyer can walk away and receive refund of the earnest money. And that is what we're looking at. So just because the seller says, I'm not cleaning the gutters, may not mean, depending on how you wrote that. And if you only wrote the seller, is to clean out the gutters, I can almost assuredly promise you that no court in the state of Georgia is going to say that the buyer can walk away because the seller didn't clean the gutters.
Is there recourse for the buyer? I mean, what then would happen?
remember that there are only certain things that survive closing unless you write it in, which we're going to talk about. So we're jumping ahead a little bit.
Oh, okay.
And no, it's okay. But unless you write in a survivability clause that the repairs to be completed herein survive closing, or the repairs herein and the requirement to complete the repairs herein survive closing, once they close, they don't survive. So you may write out all of these, repairs for the seller to do, and you get to closing and find out that not only were they not done, the ones that were done possibly were done by somebody who wasn't licensed. There may be no recourse. Now, if you get into a magistrate court issue, remember that many, if not most, magistrate judges here in the state of Georgia are not actually even judges or licensed attorneys. So if you didn't know that, that may come as a shock to you. So there is a lot of emotion that goes into making decisions sometimes in the magistrate court level when people are going after somebody for something they agreed to. So I have actually seen the court say, yes, we're going to make you fix this issue, even though, and in that particular case, they went to 4 different attorneys and 4 different attorneys told them, we're not going to be able to do anything. They're not going to do this because you've already closed. It didn't survive closing. And there may be a chance that you could get a magistrate court judge. You'll save money doing it on your own, et cetera. They did, and the magistrate court ruled in their favor. Now, it was a bad ruling based on contract, but it doesn't mean it can't happen. It's just very, very rare. And it's a chance you don't want to take. Okay. So let's talk about the handwritten versus the pre-printed. So if I go in and I realize that, let's say my binding agreement date was wrong and I want to fix it, we may go in and say, let's just have everybody initial off on it and date it and change it and correct it. Anything that you handwrite on a contract or that you, that is not pre-printed, that you handwrite or type, or that is added to the contract, such as special stipulations, they are going to prevail over anything in the contract that's contrary to those. That was a pre-printed thing. So for example, it may say in your contract that that no party is ordering a survey, but then you do a special stipulation that sellers to provide a survey for the 15 acres that the buyer is purchasing, a new survey with all lines marked. And guess what? That will prevail over any other requirement of anything that was pre-written. So it's just a very simple way of saying, if you handwrite it or type it on there, and that's not a pre-printed thing automatically in your contract, then that's going to prevail over something that was pre-printed in the contract. Does that make sense so far? Okay. And feel free to ask questions. Just because of the way that Zoom works, it's hard for me to keep up with the chat. If seller agrees to paint the entire house and in the final walkthrough, the buyer doesn't like the paint job. No. This is one of my favorite things. Okay, so let me stop right there before I move on to the construction of a special stipulation. What they're asking is if a seller agrees to paint the entire house a certain color and the buyer goes in and they painted it, but the buyer doesn't like the paint job that was done, is there any recourse? Most likely not. And the reason why is because you most likely have a special stipulation in your contract that simply says the seller is to have the entire home repainted by vendor of seller's choosing, whatever XYZ color is. Okay. That is often what I see. And as frustrating as that is, it doesn't give the buyer a lot of recourse for whether they like it or think it was a good job or not. If you want the buyer to determine whether or not they like the job performed, I would encourage you to do it, have the repair done by vendor of buyer's choice. If I'm a listing agent, I'm never going to allow you to write a special stipulation that something is to be to sell buyer satisfaction. I'm never going to allow that. So the easiest way to fix this is to have it done through vendor of buyer's choice, making sure that the vendor knows the buyer is the client, because it's much more likely that the buyer is going to have that done. I would also make certain that you not just say that the seller is going to paint something or have it painted, that you actually specify who the vendor is going to be. And the reason that I say that is because we've had a lot of sellers who have realized very quickly that they are not painters, who tried to save money and paint something and it looked really, really, really bad. But if the contract says the seller's to paint it and the seller painted it, and the buyer doesn't like it, it's really a too bad, so sad situation for the buyer. Now, that's very different than if you write a special stipulation that the seller is to have an electrician licensed in the state of Georgia to complete electrical work, repair a ceiling fan that is loose in a bedroom, and the seller does it themselves. That's a very, very different situation, because if they can't provide a receipt and show that the vendor that or a licensed electrician did it, then that is not completing the job correctly. So then the buyer would have an objection to it. Again, depending on how you wrote it, depends on whether or not it would be an enforceable objection or an objection that has recourse. So let's talk about the construction of a special stipulation. So we're going to get into the meat of this. Guys, I know that listening to me for 3 hours is not the most fun you're going to have today. I understand. I totally get it. It is a long class. 3 hours is a long time. Even for somebody like me with my ADD, it's hard to do. So I understand if you need to step away for a few minutes, get a glass of water, whatever. I don't mind that. The only thing I ask is that you just do it with the least distraction possible. I try to make this as informative as I can so that you walk away feeling like you've learned something. But I know this is a hard topic to do. It's almost as difficult as teaching people to read closing disclosures. So let's talk about this one. Construction of a special stipulation. If any wording in the special stipulation is not clear and complete, and the additional guidelines will be used by courts or arbitrators determining the actual meeting. The overriding rule of the contract interpretation is to determine the intention of the party. So all rules must be considered with the overriding proposition in mind. Some of the additional rules of construction are any provision that is unclear will be interpreted against the party who wrote the provision. So let me talk to you about this one. I get very frustrated with your industry when special stipulations are written that are adverse to your client, but it wasn't your intent, because what that tells me is that we kind of got in a hurry and we wrote something and it wasn't what we intended to do. It can be extremely costly for you doing that. We have a special stipulation on a contract right now that we're dealing with that, and I've got it written down here, and let me just read this to you. All parties acknowledge and agree that seller shall be given an additional earnest money deposit. And I already see Dana as a broker, her ears are perking up because she heard the word earnest money. Earnest money deposit of $1,000 to extend closing. Buyer can be credited the earnest money if transaction is closed by the extended closing date of blank. If not, seller gets to keep all earnest monies. Then it goes on to say, seller shall keep all earnest money whether transaction closes or not. I see your faces. Y'all don't understand it either, do you? So the first problem there is they're extending a contract with an option for additional earnest money. So the first problem that I see here is that they use the words earnest money. Earnest money by nature are already refundable monies. So by its nature, an earnest money deposit is refundable if certain actions transpire. Okay, it can become non-refundable upon the occurrence or failure of certain actions. However, if you are writing a special stipulation for earnest money for the extension of a contract, you are best off calling it an option money to extend closing. You are best, and then if they want to give them credit for it, the option monies can be credited back to buyer after closing or at the time of closing if it closes on XYZ date. But if it doesn't close on XYZ date, then the monies remain with the seller. You can do that. So you have number one, the earnest money issue. The second issue that you have that's a problem here is having a situation where you say that you're going to give it to the buyer. Originally, until they read the last sentence, I was with them. Okay, the buyer gets it if it closes by XYZ date. Seller gets it if it doesn't close, right? But I've got no idea. I literally have no idea what the intention now is, because they added the last sentence that seller is to keep it whether it closes or not. So that tells me that seller's already entitled to all the earnest money that they've already given plus this new money. But was that the intention? So now what the court would do is, okay, we're going to look at everything in the four corners. And then if we still can't determine what the intention of the parties is, then what we're going to do is we are going to then turn around and we're going to look at the communication between the parties. Now, keep in mind, who are the parties to the transaction? So you may know who the parties to the transaction are. Who are they? Nobody knows? Who are my parties to my transaction? I'll give you a hint, not you. You're not a party to my transaction. You're not. You're there as a representative and a facilitator. You are not a party to the transaction. The parties to the transaction are the buyers and the sellers. So now we're going to look at the communication between the parties. What did they agree to do and what was the intention? And then if we still can't do it, what the court may do is strike that entire additional earnest money. And we've actually had a case where they struck the entire clause for the extra earnest money, which then meant that they had to strike the clause to extend the contract because it was all done as one thing. And therefore we were now out of contract. Didn't make the contract itself void. We were just now out of contract for the extension. So now the contract had expired. So now the seller gets to keep all the extra, all the initial earnest money. And we just go back to saying, okay, the contract is dead, is basically what the court did in that case. So let me talk to you about this one. Also, if there is a problem with it, the courts could say that because the seller wrote that, by the way, the seller wrote that special stip, the court could say, we're going to make the parties whole and we're going to allow the buyer to get credit for that $1,000 earnest money. And we're going to strike the last sentence because it was, looked at as an unclear provision because of how the seller wrote it. And even though the seller didn't actually write the special stip, the listing realtor did. The listing realtor was representing the seller in doing so. And your contract clearly states that if a special stipulation is written, it's done at the request of the buyer or the seller on behalf of the realtor or by the realtor. Let's see here. Let's look at a couple of examples. Okay. You can turn your computer, your things off mute if you want to participate and answer some questions, and I would appreciate if you did. It just makes it go by faster. Seller shall repair all driveway cracks before closing. Anybody want to tell me what's wrong with this, or anybody want to tell me a better way to write this? Oh, I see some of you already tell me. Let's see what you say.
Would you need specification, like vendor specification, type of drive specification?
What type of crack is it? What cracks are we repairing? Is it a hairline crack and we're filling with caulk? Because I'm going to tell you, the seller's going to do the cheapest thing they can to repair the driveway cracks.
Mm-hmm.
Okay. And the buyer's going to expect that somebody's coming out there and they're lifting out that piece of concrete and replacing it. I mean, this is how polar opposite the buyer and the seller see it. The buyers want a perfect home. The sellers want to be rid of it and move on. So what the seller is going to do, I can assure you, is take a caulk gun out there and they are going to fill the cracks with caulk. I can promise you in the almost 21 years I've done this, that seems to be the going thing. Now, what if we say that the seller is going to repair all driveway cracks that are greater than 1 inch in width? So it tells me they're going to do the larger ones because I've seen that too, but it still doesn't tell me how we're going to fix them. And is it going to be what we're supposed to do? So let me show you a couple of things. What is the definition of a crack and how wide does it have to be to qualify to be a crack? I don't know. What constitutes repair? In my mind, a repair means we fixed something, not covered it up. So my idea of what a repair would be very different from yours, but it would also depend on what the industry standard to fix a repair or repair a crack would be as well. Is this provision vague? Do you think it's vague? Many of you think it's vague? Okay. And if it is vague, is the provision enforceable? And if it is vague, is the entire contract enforceable? What happens if the seller does not repair all cracks before closing? Okay. Does it matter which agent wrote the special stipulation? Well, we already know, yes, right? So let me just tell you on this one, and for this example, if my seller were to say that they went out there and repaired it with caulk, I would say, okay. If I'm looking at this in a reasonable interpretation of this, I would say, okay, because it is very well known that a lot of people go out and they fill them with the caulk. The Gorilla, what do you call that stuff? The Gorilla water paint stuff or whatever, the crack filler, the Gorilla, it's like Gorilla Glue, but it's made by the same company. We recently had a client that went in and they were supposed to repair driveway cracks with a very similar special stipulation to this. Concrete is white and that painting stuff is black. And he went in and just filled all the cracks with the black. They are more noticeable now than they were. But unfortunately, the buyer wrote the special stipulation and gave no provision as to how it was supposed to be done or what they were supposed to be due. And I seen in where you're saying any crack a 1/4 inch or over vertical width to be fixed by a professional licensed bonded insured person. Okay. Are most of our, in what way are concrete companies licensed? It's a very different thing than having a license. A business license is a very different thing than having a license that's required to do work. I'm going to stop right here and tell y'all a little bit about handymen, and people get really mad at me when I talk about this. You guys need to be extremely, extremely, extremely careful in your recommendation of vendors, especially when it pertains to handymen. Okay. The handyman rule is not that someone can do up to $2,500 worth of work that a normally licensed person can do. That is not what it says. What it says is that they can do up to $2,500 combined work on a property. However, wherein a plumber is to do plumbing, or plumbing work has to be done, or electrical work has to be done, a licensed plumber or electrician is still supposed to do that work. We've actually had a case here in Georgia where a realtor recommended a handyman person to go in and fix a couple of GFCI outlets. The home later caught fire, and there was over $10,000 of damage done to the kitchen. They ended up suing the realtor and the broker because they recommended that person. I'm going to tell you, you need to have a licensed electrician, a licensed plumber, or 2 or 3 because they get busy, or a licensed HVACs. Those items still require them to do to have a license. Painting does not require that you have a license to paint. You are not required to have a license to caulk. You are required to have a license to cover up outlets and finish the cover up in the construction of a basement. So if there's more than $2,500 worth of work to be done, then a general contractor would be needed to do that work. So you have to be very careful about who you say is licensed and bonded. Now, if you are going to say that I want someone who is, a concrete repair person to do it, someone who can, does business in the concrete repair work, I'm going to tell you, I would recommend that you go ahead and have your buyer choose a vendor, and then make sure that that person is bonded for their work, and that they also have workman's comp insurance and insurance in case somebody gets injured on the property. That's one that I see missed a lot. I'm trying to get back in here to see some of your questions. If you modify a pre-printed special stipulation that says that's already pre-printed for GAR, it doesn't necessarily mean that you're practicing law without a license. Because there are certain special stipulations in there that you may need to change because the circumstances are reversed, and you may need to reverse that information. Let's see here. So be really careful because of writing that you want a licensed professional to do business. That gets mistaken so often for someone having a business license. So just because somebody has a business license does not mean they're licensed to do the work in the field in which you're trying to get the repair work done. So I just want to give you all of that caution out there. Be careful with that. Make sure that you know. One of the other things that I will go ahead and talk to you real quick, just because we're talking about repairs and stuff. If you're looking at a tax report and it says that the tax bill is based on a home being 2,500 square feet and the agent is listing it at 3,200 square feet, we probably have a situation where work was done, and most likely it's a basement addition or an attic addition of some sort. that was not, did not have permits pulled when it was complete. It's a really good issue, a good way for you to look at that. And if you see that, you then need to immediately recommend to your buyer to go to the county and pull all permits for construction and additions and see if permits were pulled to complete basements. It is one of the biggest issues that we see. We actually had one recently where they took a sunroom off the back of the house and made it an additional bedroom. They did not pull permits to do it. And they didn't find out until after closing that permits were not pulled to do it. However, there was some language in the contract and in the discussions with the buyers and the realtors that the seller had fully told the buyer that they were doing the work themselves or had done the work themselves. Okay, let's move on to this one. Listing agent to obtain home warranty with a cost not to exceed $450. Okay, that's very generous of the listing agent, isn't it? Because I'm reading that as the listing agent's paying for it. I bet you that wasn't their intent. I bet you the intent was for the listing agent to what? Order it. Okay. Let's see here. Who pays for the home warranty? Is it the seller or the listing agent? Well, since the listing agent wrote it, I'm going to argue that it should be the listing agent. How long does the warranty last? Does it matter what company we're using? Is that important to you all? Do you care which company they use? And does it matter which agent wrote it? Yeah. How about this? At closing, the seller to provide agrees to provide buyer's protection plan home warranty issued by blank at a cost to the seller not to exceed blank. Said home warranty shall be in effect for a period of 1 year from the date of closing. This is a GAR special stipulation already written for you. Okay, guys, I'm going to go over this one with you because you're going to laugh with this new way that we do closing disclosures. 1 point discount buy down to be split between selling broker and seller. I already have issues with the first sentence. $1,000 to be deducted from selling agent commission with difference being paid by seller. I have no idea what a 1 point discount buy down is. I can assert assumptions here, but I cannot tell you with certainty what that really means. And then it says it's to be split between selling broker and seller. So the buyer's agent is paying for it and the seller, but then it says $1,000 to be deducted from the selling broker commission. Okay, is that in addition to, or are we now saying that the 1 point discount buy down, whatever that is $2,000? I have no idea what we're doing here. This is an actual special stipulation that I received. Okay, so let's talk about some more issues. By the way, what happens if the seller, the lender won't allow the agent or the seller to pay for a discount point or buy down the amount? Do we just not do anything? I don't know, was the sales price increased for this? I have no idea. What happens when the contract provides for something else, such as a seller paid closing costs and the lender won't allow it because this is exceeding the seller concessions? Does the seller get to just keep this too? Is this part of the closing costs? I don't know. I don't know how to fix this problem for them. Commonly misused special stipulations. The binding agreement date shall be the same as the acceptance date of the contract. I want you guys to think if you were in the business when the downturn of the market happened, and I want you to think about HUD and this special stipulation. If my binding agreement date is the same as acceptance, one of the issues we had with HUD in particular, or even some of the bank-owned properties in particular, was that they would have a special stipulation like this in their contract, and then they would say that binding was the same as acceptance. They would accept the contract, let's say on Friday, but you might not get the bound contract back until Tuesday. and your due diligence is 10 days, you've now lost 5 days of due diligence. So I don't know what to do with that. When does binding agreement date become effective? Technically, in our contract, binding agreement date becomes effective when the last person who has accepted the contract sends written notice that they've accepted it to the other party. That's when it's bound, right? Okay. What other dates are tied to the binding agreement dates? Pretty much everything in the GAR contract. Pretty much everything is tied to binding agreement date. What happens to those time periods if the binding agreement date and acceptance date is the same? You lose time, right? Okay, this is my favorite. Property misappraised for the purchase price. Okay, what happens if it doesn't? I see Beth laughing, but it is so true. I have no idea what to do here. Okay, it didn't appraise. Is the buyer coming with the extra money? Can the buyer walk away? Who determines if the house appraises or not? Is a licensed appraiser doing that? There's a lot of assumptions to be made here. And the last place you want to make assumptions is in real estate. How many appraisals have to be obtained if they don't like the first one? Who's paying for the appraisal? Okay, prior to 2008, special stipulations addressing appraisals were some of the most often misused and inadequately drafted stipulations seen in contracts. The Georgia Association of Realtors has remedied this in large part by creating appraisal contingency exhibits or creating appraisal contingency requirements within the loan financing terms. I really think that you guys need to be very cautious about trying to write your own special stipulations when they're already there. I am not an advocate of you recreating the work or the will. If the work is there, use it. It is there for a reason. It's like a 10-year-old trying to make life harder than it has to be. There are just certain rules to math that we all know. I don't care what Common Core tells you. There are certain rules to math that we all just know or should know. And there's just certain ways to do things. And if it's already done for you and it's tried and true, why would you try to rewrite it? And I think this often comes from lack of knowledge in what special stipulations GAR has already provided to you or the RE forms has already provided to you. I say all the time, you should have a copy of the GAR contract and the RE contract highlighted with your notes in a folder, along with the special stipulations for each one in a folder that you keep with you at all times. So if you're writing a contract, you can go back and find the information that you need. You never know where you're going to be when you need to write one, or where you are when you need to answer a question. So I always say keep a copy of both in your car in a folder with copies of the special stipulations for GAR and RE in there so that you know what special stipulations are available to you to use, so that when you're out and about, you're having lunch with a client and that client's contract comes over or counter comes over, you can easily look at what you need to do and amend it right there. Buyer shall have air conditioning system evaluated and seller to pay for any repairs suggested. I'm going to tell you as a seller, I'm walking out there going to say, look at it, and I'm going to say, yep, it's good. Because that's what you basically just agreed to. There is nothing in here that says who has to evaluate it. Nothing in here that says what type of evaluation has to be done. I turn it on in my house. Guess what? I walk outside, it's working. I'm good. As a seller, I'm done. I have fulfilled my obligation to you. I evaluated it. It turned on when I flipped the switch in the house. We're good. If you think I'm kidding, I'm not. It is so true. What does evaluated mean? Evaluation can take on a whole lot of different meanings depending on who's reading this. I'm going to go ahead and say to you that I believe that the buyer's intention is that an HVAC company come out, look at it for maintenance, make sure everything looks right, and give any recommendations for suggested repairs, correct? And the seller says, I flipped the switch, it turned on. And quite frankly, the seller's not wrong. What if the repairs suggested do not amount to defects? What if there's an issue on it and they reasonably assume that there's supposed to be an HVAC company that comes out and they came out and say, hey, we're making these suggested repairs. As a seller, because I'm an attorney, I'm going to come back to you and say, hey, here's the report. The HVAC guy suggests you make a couple of repairs. I'm going to send it back to the buyer. Because you didn't write anything in here that I needed to do those repairs. You just told me in your repair request that I have it evaluated. I did. They say there's $2,000 worth of stuff that needs to be done. Good luck. Because guess what? I've done what you've told me to do. I'm probably not going to fix anything. What if you do this? Let me just ask you this really quick. What if the HVAC guy comes out and says, look, I think you need a full replacement? Does the seller have any obligation to replace that HVAC? Nope. And I can promise you that this is being done after your due diligence has expired. I can promise you this is the special stipulation that is in your repair request. I'm coming to chat. I see you guys blinking at me. Too confusing, needs to be exact numbers. Leave it to buyer, seller, agent. Okay, hold on. Something's very confusing to you guys. I see several people writing about something being confusing. Let me go back up here and try to find what you're talking about. Give me 1 second. Let me see what you're referencing. Dana, do you see what they're asking on there? They're saying that something is very confusing. Not if it's working. Okay, I think, Cindy, you're talking about not if it's working at the time that they have it evaluated. Okay, what happens if it was working at the time that y'all went under contract, but the inspector noticed something, and then by the time the HVAC comes out there, it's not working? It's a whole different issue, right? Okay, let's see here. I'm trying to get up here to.
Yeah. I think the issue is when you know, agents, you have to be careful. Don't just cut and paste from an inspection report to an amendment. That's just a description. That's not a request, like Amy said, for the seller to actually perform anything. Have it evaluated. Okay, great. I had it evaluated. So what? That's all you asked me to do. Copying and pasting from the inspection report, it is not a call to action on behalf of the seller.
Right. Agreed. Okay, so let's talk about this one. Let's try this. See if this looks any different to you. Well, sometimes my computer doesn't like me. I have named her Sybil for a reason. That's my computer's name. Sometimes my car's name and sometimes my kid's name too.
Amy, before we go on to this, on that topic, I'd love to hear, I think everybody will benefit from your legal opinion, as well as your experience with real estate and real estate agents. Should a buyer's agent attach a copy of an inspection report to an amendment to address concerns with the property?
Okay, so there's two different schools of thoughts on this. One, if you attach it and you're doing the right to address repairs, you have probably just terminated the whole contract, because if the lender sees that, they are going to want to know every single repair in there, and the underwriter is going to say there's too much, buyer can't do all this, they don't have the funds, and we're not going to approve the loan. So if you ever want to get out of a contract and you're representing a buyer and you want a way to get out of a contract, send that inspection report right on over to the lender. See what happens, because you're probably going to terminate the contract, or they're probably going to deny the loan. I am not a big advocate of you attaching the inspection report unless you can attach just the specific page that shows possibly a picture of where certain damage is. So I have seen, and it's not a bad idea when something's in the attic, especially, or something that's really hard to access, them actually make a copy or take a copy of a picture and insert it to show where the damage to whatever they're repairing is, if it's not something that you can easily see or go find yourself because of what it's showing. I've seen it done where there's a furnace in an attic and a specific part needs to be replaced, and they show the part that's having issue, just so that when they get the HVAC person out there, they know exactly what they're looking at, because it's like a game of telephone. I can tell you there's an issue with an HVAC and something to do with the heating element in the HVAC. And by the time it gets the HVAC guy and they actually get there to look at it, they've heard that the filter is full and needs to be replaced. So there are times when you should attach pieces of it or give more information like a picture, and when you can, you know, pull that from the inspection report and put that in there, that might not be necessarily a bad idea. But I do not recommend that you attach the entire inspection report to something, especially something that the lender is going to receive. I would recommend that you give them the pieces that they need for what y'all are requesting to have done. Okay. And now also keep in mind, I want to talk to you about this home warranty issue. I don't know why this came about, and I cannot explain it, because a reasonable interpretation of everything else that we do would tell you this is not going to work for you. If you have repairs that you want done and the seller says, we'll give you a home warranty instead, say no. Because if it's a pre-existing issue and your buyer asks for it to be to get a, and your seller wants to give them a home warranty, it's most likely not going to be covered by the home warranty company. They will not insure or repair pre-existing conditions. And more home warranties companies are requesting copies of the inspection reports, especially for things done within the first 90 days of ownership. Okay. So if you have a buyer who is buying a property and there are repairs to be completed, and they say, oh, well, we'll just give you a home warranty for that, and then they can have the home warranty company come out and do whatever needs to be done after that, that is not going to fly. It's no different than if you buy a home. If you have a seller who writes a report on their closing disclosure, and it says, yes, home flood, basement flooded in 2012. And you knew there were a lot of rains, but you didn't ask what they did to fix any of the leaks. Guess what? You can't go back after closing and say, well, they didn't repair the leaks. They didn't tell us there was an issue. Well, they may not have known about an issue, but you certainly didn't do the due diligence to find out what was done. So the buyer might not have the right to go back and do anything because it was disclosed in the seller disclosure. So I would be very careful about this whole process of looking at this and being very careful about the home warranties. I would tell the listing agent, we prefer to get the repairs completed. A lot of times the home warranty is a lot cheaper than whatever you're wanting to be done. We have had situations where the home inspection says, you know, this dishwasher is leaking just a little bit of water on a consistent basis. I can see it up under there. I can see it up under the sink, that there's consistency with leaking. It needs to be replaced, or the lines to it need to be replaced, but it's also not running properly. I would recommend a full replacement of the dishwasher. And you ask for a dishwasher, and then the seller comes back and says, no, we want to give a home warranty, and they can have the dishwasher replaced later. You're probably not going to be able to get that dishwasher replaced. So I want you to be very careful about this. What about this one? Buyer and seller acknowledge and agree that the following item or items in or on the property cannot be properly inspected due to seasonal weather conditions. Seller warrants that the items are in good and working order and repair as of the binding agreement date and without defect as defined by this agreement. If for a period of blank days from the closing date of this agreement, buyer uses such items for the first time and finds the items are not in good and working order and that such items are in fact defective, seller should be responsible at seller's sole expense to repair and or replace any defective items. At that time, if buyer does not use such item for the first time within the period specified above, or if the defects for which the buyer complains are caused by the buyer or guest, then the seller obviously, seller's obligation to repair such defective defects is such in such items shall terminate. Where you're looking at this is like pools, winter cabins that come with a dock and sometimes a boat, those types of issues where things are winterized. This is the language that's, you know, that there's a GAR special step for. I would just be careful of the days and the time frame of when they're going to have an opportunity to look at it and make sure everything's in good and working order. Make sure you give your buyer plenty of time. Okay. Seller to provide 1-year termite bond. Why I'm still seeing these, I will never understand, because a 1-year termite bond tells me nothing. Not even a little bit, tells me nothing at all. 1-year termite bond simply tells me that somebody's paying for 1 year termite bond of some sort on a property. We don't know who's providing it. We don't know what at what cost. We don't know if there's going to be an inspection prior to closing. So we still don't know if there's actual termites on the property. And we don't know if it's going to be a treatment or repair bond. And I also don't know what type of bond it is. Is it a bait system, or is it a what type of system is it? How often does it have to be paid? Is it quarterly? Is it, whatever it is? I just don't have any clue on this one, what you're doing, other than somebody's supposed to pay for something, but I don't know that what's going on really. And I don't know how long it's going to be for. So is it a quarter? Is it a year? What is it? I just have no idea. So these are some of the issues that I am constantly struggling with when I'm reading your contracts. I just don't know what it is that you're doing, other than these are the things that I'm seeing. So let me talk to you about a couple of cases, and I want to make sure not to give you the answers. Okay, this is my favorite. I actually just saw this contract, this special stipulation, something very similar to it last week. Dana, don't cringe. I actually did see this. In this case, the seller sued a buyer to enforce a real estate contract. One of the stipulations stated that seller could remain on the property for 30 days after closing rent-free, and that after the 30 days, seller should pay rent equal to the mortgage payments, taxes, and insurance as long as necessary until seller finds a new home. In this market, how long do you think that's going to be? How long does seller get to stay?
It looks like to infinity.
It looks like to infinity. Well, I mean, as long as necessary, what's necessary? I mean, it is a market where it's very hard to find reasonably good homes right now. There are very few Joanna Gain homes out there, and we don't know what the seller's looking for. But okay, let's move forward and ask a couple questions. What, if anything, is wrong? I want you to tell me what you really truly believe is wrong with this special stipulation, besides the as long as necessary. Is there anything else in there? Are we good with everything else until we get to the as long as necessary until seller finds a new home? Are we good so far? They can stay there for 30 days and they're going to pay a rent payment equivalent to the mortgage payment, taxes, and insurance. Are we good on that? I think we're okay there, right? Other than, I don't know who's paying insurance, who has the liability, how the home's going to be left, and I don't know if the seller does any damage to the home or the home's damaged, who's going to take care of that? So there are a whole lot of other questions. But as far as them saying there, we know what the rent's going to be, right? Okay. Now, let's ask this. Is the stipulation clear and unambiguous? Without that, as long as necessary? Probably, but there's still other factors that we should have addressed. Who do you think wins the case? And I really want to know who you guys think win this case. Do you think the buyer wins this case, or does the seller win the case? Y'all think the seller wins and they can stay there for as long as they want. Buyer. Okay, so let's look. Buyer won this case. So whoever said buyer is in the minority in that one, and they won. Buyer won the case because the stipulation is too vague to be enforced. The fact that the stipulation was indefinite in time rendered not only the special stipulation unenforceable, but it rendered the entire contract unenforceable because it was too vague to make a determination as to the intent of the parties. So we invalidated an entire contract because of a really poorly written special stipulation. Correct? Okay, let's see what else we got. How could the intentions of the parties be worded so that stipulation was clear and unenforceable? I'll go ahead and tell you, one of the things that they could have really done here was stopped it at that and just put that in the event that seller is unable to leave or does not leave premises or unable to find a home within 30 days, at buyer's election, they can extend for an additional 30-day period of time at the same cost of rent, something along those lines, just to bring it back down into a reasonable amount of time, keeping in mind that most lenders require that the intent for occupancy be occupancy within 60 days of closing. So that's another thing that you also need to think about.
Can I ask you a question, Amy?
Sure.
So in a scenario like this and the buyer wins, they still own the home. But when you say the contract was unenforceable, are all
They no longer own the home. They've basically unwound the entire thing.
So, but they still have to pay commissions and all of those things, or is there then like a potential recourse against the agent?
If a court rules a contract void and unenforceable, we put the parties back into the situation they were as though it never occurred. So the realtors would not be entitled to commissions. The buyers would not be entitled to the property, and the sellers would not be entitled to the sale or the funds from it. You literally have to go in and unwind the whole transaction.
Okay, so the buyers don't even own the property anymore. So
the buyers won't even own the property anymore. No.
Wow. Okay.
Yeah. So that is one of the big issues of what can happen if we go through and see all of this take place, and it does take place. We've seen them do this a number of times. Okay, let's look at this one. Contract. Oh, y'all, if you don't know about rezoning, please get a mentor. Okay, please, I'm begging you, get a mentor if you are not sure about rezoning. The contract involved real estate was to be rezoned. The contract especially stated that it was subject to rezoning. And in addition to saying that it was subject to rezoning, it said that it was subject to rezoning. That is the quote. That's what it said, subject to rezoning. That's it. Okay, what rezoning? I have no idea what type of rezoning it was, and the court just flat on its face said it's void, unenforceable. It's too vague. There's nothing we can do with this. We don't, they didn't even put that they were rezoning from one thing to another. They didn't even give us options of what type of rezoning they would be seeking. They didn't tell us a time frame. We don't know how long this is going to take. Is it just subject to rezoning from now until infinity? Which we've already learned that, timelines are very important to the courts, that you can't just leave it out there for indefinite amounts of time with no repercussions and no way to fix something. So yes, it's unenforceable and it's void. So that's a big one that we just need to really pay attention to. I see this one on subject to rezoning contracts a lot, where they will say that it's subject to rezoning of buyer's choice. Okay. How long? How long do we have? How long in a COVID world do we have to get zoning fixed? How long in, I just don't know how long we have to get this done. And I have no idea what we're seeking or what type of zoning we're seeking. And so with that being said, we are going to say that it's not enforceable. I actually had one last week that I sent to my realtor. I sent back to my realtor and I just flat told her, look, this is an unenforceable contract. There were 4 stipulations on it for zoning, none of which had any time frames, none of which had any plausibility in being able to figure out what they were trying to do. It just said it was subject to buyer's choice. Did not give me any other information than that. And there were 4 references to that in the contract. But I did not know. Oh, and the closing date was TBD. And the reason closing date was TBD was because it was going to be within 15 days of rezoning approval. But I had no idea how long they had to get rezoning approval done. I'm going to do one more, and then I'm going to give you guys a break, and then we're going to come back and finish these up. And then I'm going to give you some really good special stipulations that I'm going to see if Dana can share with you from us that are stipulations that I and other law firms have written that we have given out over the years. And then I have a whole bunch of other ones that I'll share with you as well. So let's go over this one. This is a more recent case. It's 2007. Court interpreted 2 special stipulations contained in a purchase and sell agreement. Provision stated seller will record a set of covenants selected by purchaser for subdivision before the close of any lot. So seller was to record them, buyer was to provide them, and it was supposed to be done before the close of any lot. The second special stipulation simply said that the purchaser would obtain financing through the Bank of Georgia. At closing, purchaser did not present any covenants for the seller to record, and the purchaser decided to use a different lender than Bank of Georgia. The seller refused to close, even though the purchaser and bank were present at the closing and had certified funds, which now would be a wire because we can't do certified funds anymore at closing. The seller contended that the buyer breached the contract by not providing a set of covenants to record and by not using the lender specified in the contract. The buyer sued for specific performance of the contract. Who do y'all think won? Any guess? Y'all think the seller seems they were a bunch of liars. What did I say about buyers, Jim? I told you, right? Who do y'all think? Okay, so buyers, sellers. Wow, y'all have a pretty good difference of opinion. Okay, let me tell you what the court said. And I love that I can screenshot and only show you part of this. So let me just show you what the court said. First of all, the special stipulations were not well written. It does matter who drafted them. And they could have been better written by stating that they would provide a copy of the covenants. And if they didn't provide a copy of the covenants, then the developer could record a set of covenants of their choosing in lieu of that at the time of closing. And then if it were to be that they had to use that particular Bank of Georgia, then they could have said in the event that they don't use that Bank of Georgia company for their loan, then seller has the right to terminate the contract. So can I reasonably interpret the party's intentions? And then we need to always think about the cardinal rules that we went over. So the court reviewed the stipulations and determine the intent of parties and found that the stipulations were clear and unambiguous. As to the covenants, the court found that the seller's agent drafted those stipulations, so any interpretation must be construed against the seller. The court found that since the stipulations did not require the buyer to select a set of covenants and had no duty to do so, it was basically reviewed as merely a suggestion that they have it done. The court also looked at the fact that the stipulation did not state what would happen if the buyer failed to do so, which we've talked about. And since the covenant did not impose an affirmative duty on the buyer to present a set of covenants, the buyer did not breach that stipulation, the court concluded. So as to the lender, the court recognized the buyer was ready, willing, and able to close. Some financing provisions are typically for the protection of the buyer. Since financing provisions are for the protection of the buyer has the right to waive the financing provision of a contract. They could have turned it into cash and said, I'm paying cash for it. Therefore, the buyer did not breach that stipulation, and the court ruled in favor of the buyer on both clauses. So let me say this to you. If you want something to make sure it's done, you go through the typical who, what, when, where's of a special stipulation that we all know. But the problem is that you often fail to tell me what if. So what if it is not done? What happens if it is not completed? What if they don't finish? What if they don't do the repair? What if they don't provide the termite bond? What if they don't do something? I don't know what the repercussions are, and that often leads me to make a decision or give the information that I believe that the contract term for that would be unenforceable, and that the buyer often has the responsibility to proceed forward with the closing. So I'm going to stop right here. I'm going to give you guys 15 minutes, right, Dana, 15 minutes. So we're going to do a 15-minute break until 11:50, and then we will come back and we will finish this through 1 o'clock. Fair enough?
Sounds great. Amy,
Okay.
I am going to reclaim the host, and I think you have to stop your share screen.
Yes, got it.
All right. Awesome, everybody. All right. Come back in 15 minutes, which will be 10 till 12. We'll do the course evaluation and finish up. Awesome. When you do come back, type in again your name, email, license number, and we'll see you in 15 minutes.
Well.
All right, all right. Welcome back, everybody. Welcome back. Once again, everybody, please type in your name, email address, real estate license number, and I've also included Amy's contact information. And I am going to launch a poll. So the poll will serve as the course evaluation. You will see 4 questions that will appear on your screen. They should appear now. And once you answer all 4 questions, at the bottom, the submit button will light up blue and you can submit the poll. If you have technical difficulties, don't worry about it. Just do the best you can do. I am leaving this poll up through the end of the class. It is anonymous and it does serve as the course CE evaluation.
Be
again,
nice.
Right before you leave at the end of the class, one more time, just type in your name, email address, and license number. And Amy, a question that I got earlier is, will you be sharing the handouts that you have been going over in the course?
The forms that I'm going over right now, I will be sharing the special stipulations ones. I mean, I don't mind. I mean, it's not, I mean, these are just to put them up there for you guys to be able to read along with them is what these are for. But I will be sharing for certain the special stipulations we'll go over shortly.
Awesome. All right. I'm going to make you host again. I'm going to mute everybody. Feel free to unmute yourself if you are asking a question or ask in the chat, but then please mute yourself afterwards. I'm going to mute everybody and then I'm going to make you host. Amy, you may have to unmute yourself after I mute everybody.
Okay.
And let me find you and make you host. All right. Take it away.
Okay, here we go. Okay, back at it, right?
Yes, we're good.
Okay, there we go. All right, let's see here. Let me go back down here a little bit more. Okay, we're going to go over a few more cases and then I'm going to jump right into going over some special tips for you that either I've written, other attorneys have written, whatever. We'll go over those and kind of show you what some of the things that we've seen are. This case involved a special stipulation that contained a leasing and management agreement. It's at its sole discretion, broker will make best efforts to conduct inspections of leased property in order to protect property from damages. However, it is in no event will damage to the property committed by tenant or damage to the property that is occasioned from any cause whatsoever be deemed to be the responsibility of the broker. Okay, in this special stipulation, exactly what did the broker agree to do? Can y'all tell me what the broker agreed to do? Nobody? Okay, so, okay, let me just make sure we're in here quick, hold on. Does anybody know what the broker agreed to do? What was the broker's concept? What did the broker say they were going to do? Do we know? What the broker actually did here, and I'm just going to give you this. I've got a couple of you that are replying. What are you saying here? Assess, nothing. Might have it inspected, best efforts to do X. Okay. Well, let's talk about what they actually agreed to. First of all, it was in the last stipulation, we said that the mere writing of the special stipulation that they were to use a certain, bank did not mean that they had an obligation to. It also did not mean that they had an obligation to record covenants. It only meant that they had a option, since there was no consequence to it, to just simply, suggestion for them to have covenants done. So in this situation, it's very similar. That the broker basically, if they decide they want to do it, they can, but they don't really have to do anything. It's a poorly worded special stipulation. It is not clear with the way that it's written. But here's what it says. The owners of the property sued the broker when they became dissatisfied with the quality of renovations and repairs being done on the property. I'm going to tell you that a lot of management companies, not all, but a lot, do very, very poor work when it comes to the maintenance of the properties with which they're managing. They are going to save as much money as they can, and they are going to possibly get people in there that aren't going to do it to the owner satisfaction. They claimed that the broker, by virtue of the special stipulation, breached its duty to ensure the quality of the renovations and repairs when it did not diligently supervise and oversee the renovations. After citing the cardinal rules of contract construction, the court found that special stipulations were unambiguous and capable only of one interpretation. And that interpretation was that the contract merely authorized the broker to supervise and renovate and the repairs and renovations. It did not require them to do so. They also looked at the provisions in the contract for confirmation of that interpretation, since the broker was also authorized but not required to take a number of other actions in performing its property management roles. This is one of the biggest issues I come up against when I'm dealing with transactions where the seller or the owner of the property, the owner of the property has come into some contact with a management company, and they go into the property after a tenant leaves and they realize that there is a lot of damage to property or a lot of things that they thought were going to be done that were not done. We actually had one where apparently the granite countertops were broken by a tenant. Somehow the tenant managed to break those granite countertops, and they actually replaced them with Formica. Well, the contract stipulation said that repairs would be up to the broker's discretion. It didn't say anything about them having to do repairs with like kind. It was inferred by the buyer that that was the case, but that doesn't mean that's what the management company agreed to. This is a buyback provision. In the event the buyers are unable to build on any lot or install a conventional septic tank on any lot, seller agrees to buy back the lot. Okay. I'm going to just ask you, what does buildable mean? What does it mean that they're unable to build? Are they unable to build on it because the county won't allow it? Or are they unable to build on it because now they've run out of money? I don't know. Is it sufficiently clear to allow a third party to enforce it? What if those parties had to sue using the term buildable? Is it technical or common term? And what about the conventional septic tank? They didn't define a lot of this. If there is no disagreement on these issues, is there enough information to allow a buyback of the lots? Of course, a dispute arose, or we wouldn't know about the case, not over whether the lots were buildable or whether the conventional septic tank could be installed, but who was to pay the closing costs on the buyback of the lots. The original buyer insisted that the original seller pay not only the closing costs, but the original seller also pay its interest expense, lost profit, and other fees and expenses. The original seller agreed only to pay the original price for the lots. The court found that the special stipulation was ambiguous because it was not complete. Special stipulation did not state who was to pay for the closing costs if the buyback of the lots occurred. So the court tried to ascertain the intentions of the party and look to the original contract and agreement with regard to the payment of closing costs on that transaction. I'm going to tell you, I think that they overstepped here a little bit, because I don't think that that can, reasonably be interpreted that if the buyer paid their own closing costs and something was wrong with the land and they couldn't build on it, that automatically means that the buyer has to pay for the closing costs on the next one and so forth. But here's what the court said. The court said, since the seller paid for the closing costs on the initial sale, the court concluded that the seller was responsible for paying the closing costs on the buyback closing as well. The court also determined that since the payment of interest, profits, and other costs was not contained in either the contract or the special stipulations, then the parties did not intend for that to be a part of the agreement. So the court said, buyer's not getting all of that, but we're going to make the seller pay for the expense to close the lots. I would argue that it was more ambiguous than that, and that it probably should have been voided. Seller warrants this property is zoned for garden apartments. The buyer learned from a site engineer that not all the property was zoned for garden apartments. In fact, about 4 acres were zoned for residential use only and not for apartments. When he learned this, the buyer refused to close and demanded return of his earnest money. Is a zoning classification something that can be the subject of a special stipulation or a warranty on the part of the seller? It can be, but it doesn't say that it simply says that the seller warrants the property is zoned. Typically, who has the burden of determining the zoning of the property? And how about other things like school district, size of lot, square footage of a house? Whose burden is it to find out these things? Well, if the seller warrants it, then it's the seller warranting that what they're telling them is 100% accurate. If you just say all parties agree that the property is zoned for garden apartments, and everybody signs off on that, that's no warranty. And then it definitely falls 100% on the buyer's responsibility to do. But look what the court found. The court confirmed that zoning is typically something that both parties have equal access to. Since the governing authority that has the official, since it's the governing authority that has the official determination of zoning, not the buyer or the seller. However, in this case, the seller voluntarily put that burden on himself. Since the seller's warranty could not be accomplished by the closing date of the contract, the buyer was awarded the return of the earnest money. I want to just tell you this, and I just want to share this with you on this one before I go any further. This issue with zoning and seller warrants, if you want to make sure that something is accurate, and it is, you go back and you ask the seller, hey, is this on septic, or is this, well, or is this, public water and sewer? And they come back and say, hey, it is public water. I'm going to recommend that you put a special stipulation in an amendment, or in your initial offer, seller warrants that property has running public water on it, not access to public water, because access to would mean it's easily accessible to get, right? But if you're warranting that there is running water that is, municipality provided, and it's public water or public sewer, you want to put that the seller warrants that there is active public water and public sewer tied to the house. In addition, there may be a well also, but you want to make sure that they warrant it. And the reason that you want to warrant that information is because you want to be able to hold the seller responsible. We've had a lot of people come to us at closing and say, we were told that there was public water and public sewer. We have an email from the seller saying that, yes, it's public water and public sewer. And then they get right before closing and find out that there's a septic, and they don't want to be in a house with a septic. Well, if you didn't put it in the contract and you didn't get a warranty from the seller, guess what? You're stuck with a house that doesn't have public water and public sewer. Okay, let me go ahead and go on to this one. Okay, I want to just do the summary really quick, and then we're going to go through some of these special stipulations. Like everything in real estate, we always talk about location, location, location. In stipulations, it's more about being exact. Use clear, unequivocal language. Use direct words with mandatory words like shall or must if appropriate. Use non-mandatory words like may or may elect if appropriate. If you want to give a buyer an option to get out of a contract for the seller's failure to do something, you may want to write a special stipulation that says buyer may at buyer's election terminate the contract or do some other form of something. Write the special stipulation with the assumption that someone not involved with the deal will have to read it, i.e. me. And remember when you're writing these that the average U.S. Resident reads on about a 7th grade reading level. So you need to write it in such clear words. I don't know why it annoys me, but it does. It's one of those pet peeves that it's almost like, nails on a chalkboard thing for me, is when I have a realtor that sends me over a contract that has therefore, wherewith, and all this legal language. I'm an attorney and I don't write like that. I was taught a long time ago. I had a phenomenal writing teacher in law school who was amazing at getting the point across to us that anyone that's reading something should be able to understand it fairly easily. There are certain concepts in law that are not easy, that are harder to understand. And sometimes people aren't going to be able to understand the concepts of those things. But when you're writing basic things, because for example, when you write a complaint and you file a complaint with the court, the complaint has to be verified. And what that means is that the buyer has to read it, review it, and agree to it and assert that everything in that is exactly what they intend it to be and that those are the issues. Now, they may not understand the concepts of legal law, like, for example, why you're suing under a tort case for, one issue, but they would understand the facts of what you've written. If you read something and you're like, and you get it from a buyer's agent or you get a counter from a seller's agent that's a little fuzzy, clean it up right then. Clean it up and just say, look, I think your intention on this is, this, but when my client read it, put it back on your client if you have to. When my client read it, it wasn't clear to them. So I'd like to clean it up just to make sure there's no question, because if it wasn't clear to them, it might not be clear to someone else. Let's just go and clean it up. If it means enough to you that in your client that you have a deadline by which it occurs, or which by what it doesn't occur, I need to know what happens if it doesn't occur. I would recommend that in your special stipulations for repairs that you have a survivability clause. And what that simply means is, you do an amendment to address concerns. At the bottom of that amendment, you put something along the lines of seller's responsibility and requirement herein to complete the work as stated herein shall survive closing. So be it. You might want to add, and I have a client who adds, there's basically 3 special steps at the end of each of her amendments to address concern. The first one states that any work to be completed shall be completed by a person licensed to do that work, i.e. a plumber. A licensed plumber will complete any plumbing. A licensed electrician will complete any electrical work. Licensed to do business in the industry in which that work is being required. And then she puts in there that any requirement of seller to complete these repairs, or the requirement of seller to complete these repairs and to do them as stated herein with licensed vendors shall survive closing. And then she uses another special stipulation that I wrote that I'll show you in just a moment and give you copies of. And it basically says that the sellers to complete the work by licensed people to do the business, to do the work that it's supposed to be done. And then it goes on to say that it's supposed to be completed X number of days prior to closing, with receipts being provided to buyer therein. In the event that the buyer does not, or the seller does not complete the repairs by 5 days in advance of closing, or whatever time frame you choose, buyer may, at buyer's election, obtain vendors from buyer's choice and for the work to be completed after closing, and pay said vendors from seller's proceeds at the time of closing. Okay. And the reason that we did that was because, and you can also put or terminate the contract with full refund of earnest money. The reason that we did that was because we're having a lot of sellers come in and not do what they're supposed to do. They're not doing the repairs. They're not getting vendors that are licensed. They're doing all these little things. So when they're not done properly, it gives the buyer no recourse to pursue them. Okay. And it gives the buyer no recourse to make sure it gets done at closing. So if seller were then to refuse to allow it to be paid out of their seller's proceeds, buyer would then be able to terminate the contract. We want to make sure that they have the right to terminate the contract and get their earnest money back, or that they have to pay it out of the closing. We talked about this yesterday in a sales meeting, and I just want to share this little example with you. And Dana, I'm going to make this very, very, very simplistic. I also want you to be very careful when you're doing split closings in a COVID world right now. It's very hard for us as closing attorneys to always know when somebody wants to have a split closing and when they don't. It's up to them. We're wearing masks in our office when we have clients in here. My biggest issue is, especially in situations where they're going to multiple law firms or multiple offices within the same law firm, and they're signing at different days on different times or whatever. We've had several instances where the buyers went and signed at one day or time with one office, or either possibly the same office, just different day and time. And the sellers came at a different time, and the buyers had a stipulation that work was the stipulation I just read to you, that it was supposed to be done by a certain day and time. And they had it on the buyer's closing disclosure that the seller was to pay for those repairs. Buyer sent the repair invoices over. When seller came in after buyer signed, seller refused to sign, saying that they didn't agree to that wasn't their intention, that their intention was, because they also had reduced the sales price, to reduce the sales price in lieu, but they didn't intend to do both. Well, nobody called the buyer to tell the buyer. And I've had this situation happen in multiple different variations of this. I would make sure that at closing, you ask for a copy of the closing disclosure that the buyer signed with the buyer's signature page, and a copy of the closing disclosure that seller signed, the Alta combined that the seller signed, with a copy of their signature page, to make sure they all signed off on the same thing. We've just had a number of issues where things are getting changed, or people are signing at different times and being told different things, or that the intention was different. And we usually get on the phone with the parties and try to find out, and then don't fund until that's done. If you're also signing at different times, make sure there's an escrow agreement so that everybody knows it's not funded until it's funded and what the requirements for funding are. We've had some situations lately where all they're waiting on is seller's signature. Seller comes in and then starts changing things, and or decides that they want to do something different, and it's delaying the closing without that being really the intentions of the parties. So look at this special stipulation here. All parties agree that the repair work contemplated and agreed upon herein shall be completed not less than 3 days prior to the closing date of blank. All work shall be completed by vendors licensed in the state of Georgia through the proper state licensing board to complete the work required herein. Sellers shall provide to buyer at least 3 days prior to closing evidence of vendors licensed to do repair work, invoices, and paid receipt for all work completed. Should the seller not complete the work required herein at least 3 days in advance closing, buyer shall have the right to either immediately hire vendors of buyer's choice and have work completed at seller's expense to be paid at the time of closing from seller's proceeds, or terminate the contract and receive full refund of earnest money deposits. You guys can caption that. You can take a picture of it. You can do whatever you want. It's yours, free to use. I do not mind. Take it and do with it however you want. The only thing I would just recommend is that if you want this to survive closing and there becomes a dispute and you end up having to close because they refuse to pay for it, you might want to add the special stipulation just below that seller's requirement to complete the work herein or failure to do work herefrom shall be required to be at seller's expense. So, shall survive closing. And then that way the buyer can always take them to court if they have to, still get their home and then take them to court after the fact. Okay. Did y'all get it? I'm fixing to turn it off. Okay. Those of you that wanted it. Okay. Give me 1 second. I stopped sharing. Let me see here. I've got one more thing to share with you guys, and we don't have very long to do it. Okay, let's see here. Okay, another big issue that I'm having is people, y'all, I don't know why this happened. I don't know where it came from. Dana may be able to give you some insight into this a little better than I can. I am and my kids will tell you, person who says you are going to take responsibility for your actions, whether you want to or not. Okay. I am a big advocate of you taking responsibility for the things that you do, say, etc. If you wrong somebody, apologize. It's not that hard to say I'm sorry. Although for some people, it's as though you're taking their left kidney and asking for the right one at the same time. I really get frustrated when buyers and sellers call me and they are complaining about things that you have done, said, or what have you. And I get really frustrated with this because my response to most sellers is, but you agreed to it in the contract. Well, my realtor didn't tell me it was going to be so expensive. Whose responsibility was it to check that before you agreed to do the work? And your realtor isn't an contractor, so they may not know how long or how much or whatever the information you're wanting is going to cost. They may not know that information, and it's your responsibility before you sign something to review that. And I have sellers all the time say, but my realtor or my agent didn't tell me. Okay. But did you read your 8 pages of contract? Because it's in there, but they didn't tell me. But did you read it? Because you're obligated to read the contract. Now, y'all, that does not negate your responsibility to do your jobs. The biggest thing you guys fail to tell your sellers is that there's an 8-day unilateral right to extend the contract. When contracts don't close on time, your sellers get really upset that they didn't know that the buyers had an 8-day unilateral. I hear at least once a week, I'll never use this realtor again because they didn't tell me the buyer had the right to extend the contract. And they get really upset about it. Y'all need to tell them that there's an 8-day unilateral. You need to let them know that. Okay. The other thing I'm going to tell you is you need to tell them, as far as the 8-day unilateral goes, that you need to explain to them what that really means to them, that their contract is set to close on this date. and all of the mechanisms of the gear shift thing with 1,000 parts have to fit exactly in there for that to happen. And in a COVID world, I'm going to tell you my express frustration with COVID is I believe it's a 5-letter word for excuse. People that know me know I'm tough, but I'm going to tell you, I think it's an excuse. There is no reason that things are taking place in our world as they are because of COVID. There is no excuse when you're telling me that you're running 3 weeks behind on closings when you're already getting 30 days to get them done, that they can't close, and it's taking 7 weeks to get a closing completed. What that tells me is, yes, there's going to be some of that because the refi boom has hit. Interest rates are really low. A lot of people are refinancing. A lot of people are buying properties. But what should be the priority for most mortgage lenders? Their purchase sales, right? Because those are time specific. Refinances, if you got them locked, they can close in 30, 60, or 90 days. That is not as vehement of a push because of a time frame and a possible loss of money as right now we're dealing with. That's not as big of a deal as a purchase sale transaction. And I have, in the past 6 or 8 weeks, I would say it was upward of more than 10 transactions that have been canceled within 4 to 5 days of closing. Some the night before, one at 6 p.m. and it was supposed to close at 9 o'clock the next morning. Closings were terminated because the loans were denied at the 11th hour. And that's because they're not looking at them until the 11th hour. And that's not all lenders, guys. I want to make this very clear to you. That's not everyone, but it is a lot of them. We had a staff meeting in my office a few weeks ago, and I thought it was very telling that one of my staff members said, well, if these closings here on Monday, because we always try to look at what we have for Monday to figure out where things are going to shift on Thursday and Friday and try to make sure we have enough coverage and make sure everything's going to go because Fridays are always super busy. And her response to me was, well, we could probably slide them into these 2 time slots because this is the first time those 2 loans have been scheduled to close. So the amount of shifting and not making the closing dates is extraordinary right now. I would tell you, just to give you some numbers, we've had a couple of weeks ago, we had like 12 or 14 closings scheduled. I think we ended up closing 3 that day because we couldn't get loan packages. And one of them ended up being a cash deal. The following week, I think we had 15 closings for one day on a Friday, and we ended up closing 4 of those because we couldn't get loan packages. We last Friday, and I'll tell you exactly what the number was. We were pretty busy, but last Friday, just to give you an example, we had a whole bunch of shifting that went on. We were supposed to have 2, 4, 6, 8, 10, 12, 14, 16 transactions, and we closed 2, 9. And many of those were already rescheduled a second or third time that we closed. So we're hitting the first closing date is becoming sort of an issue of that's a lower percentage than what we normally see. I would recommend that your financing contingencies be extended out as far as you possibly can get the sellers to agree to them. If you cannot get a letter of full loan approval or an email of full loan approval from your lender prior to the expiration of your financing contingency, I would ask for an extension of it right now. That's just me telling you to try to protect your buyer. Do what you can to try to protect them. And if the buyer says, look, they're not going to extend it, but I want to move forward, I feel pretty confident about this, you need to send them an email. Your financing expires. If you want to be able to terminate and get your earnest money back, we need to do it now. If not, then, go ahead and proceed. But just know if you have to terminate after this, you will lose your earnest money. The other thing I want you to have a conversation with your sellers about is the need for more earnest money and why you're countering. Don't be so what's the word I'm looking for? Bent on trying to get a contract binding that you miss the details. I do not recommend that you take in less than $2,000 of earnest money. Someone buying a $100,000 loan still has to put 3.5% down. It's not worth my time to let you go under contract on my house for $500. It is not worth my time, my energy, or my sanity to do that. Especially not if your buyer can cancel basically for any reason and just lose their earnest money. right? Because you can't sue a buyer for specific performance now under our contracts. So what do? So the only thing that you have a choice to do is to make sure you're getting enough earnest money that if it falls through, it pays for the seller's mortgage payment for the next month or so. That whatever is transpiring, that you've got enough earnest money there. Remember to provide the provision shall survive closing in GREC contracts in order to survive for items as repairs, purchase of home warranties, etc. The entire contract survives closing in the RE forms. To accept a contract after the time limit, here's a special stipulation for that. Seller warrants specific matters in a seller's disclosure, states that blank property is on a sewer, not a septic, and seller warrants this information, this disclosure and seller warranty of this information to survive closing. That clause right there actually protected one of my clients. This past year, they thought they were going to have public water, went to connect the public water. They weren't moving in for about 30 days, went to connect the public water, and they said, there's no public water, but there's public water at the street, but you would have to buy a meter and get it connected to the house. It's $5,000 just for a meter in Cobb County. Plus you have to pay for all the connection. So it can get very, very, very expensive. So I would be cautious of that and make sure that they're warranting it, and that if you're going to warrant it, that you, see that you do it at not less than that if you're taking the time to do a warranty, make sure it survives closing. I'm sorry, I was reading it at the same time. Can you also request a copy of the seller's closing disclosure, or only the one for your? You can request it. Most sellers won't give it to you. Is the 8-day unilateral right extension automatic on transactions in GAR forms? For 3 reasons. The lender is not ready to close. There are title issues, or the attorney cannot get them back on the books. So if you do an 8-day unilateral to close, and you were supposed to close on Friday, you would have the next Friday and then the following Monday. If I don't have time available on that Monday, or let's say your original closing is supposed to schedule on a Monday, you would have the 8-day unilateral right for me to get you back in. So let's say that you're supposed to close on a Friday. I can't get you in. I can get you in on Monday. You can use the extension for that. Seller hasn't cleared up title defects. But by the way, let me just address this right now for you guys. Whose responsibility is it to clean up title defects on a property? Don't be shy. Whose responsibility is it to clean up title defects? It's whose? It's the sellers. That's right, it's the sellers. It is not the title companies. It is our responsibility to make sure they're cleaned up property, but it is the seller's responsibility to clean up the title. I have so many sellers that we will call. I'm dealing with 2 right now that we will call and say, you have a title issue. Well, I've refinanced it 4 times. I don't care. You have a title issue. And the thing that you guys need to keep in mind is that most law firms are only going back to the last seller, maybe 2 last sellers. And most lenders only require a 24-month chain of title for closing. But the Code of Ethics for the State Bar of Georgia requires that we are supposed to do a 50-year title. So does our agency agreements with our title insurance companies. And most law firms are not doing 50-year title searches right now, I can tell you. I am seeing it left and right. When I call to clear up title issues, I'm constantly getting the statement of, well, we didn't go back that far. We didn't see it. We didn't know about that one, or we don't have any information on it. And especially when they're doing refis and they have these weird banks that are doing their refis in home, and they're sending a notary out to have them sign. They're not looking over title. They're just getting docs signed. Okay. All right. There's an escalation clause in here.
Maybe also, just to interrupt you, if you'll just address the 8-day unilateral in the RE forms.
Yes. Hold on one second. I certainly will. Give me 1 second, Dana, and I'll go back to it. I just want to look at this escalation clause really quick. Can y'all see that if I highlight that? Can you see that? Okay.
Yes, we can.
Okay, let me do this really quick and then I'll go back to the 8-day unilateral on the other, okay? Buyer to pay blank above the highest received verifiable offer not to exceed total price. I want y'all to read this. Top sales price buyer is willing to pay or is qualified to pay for the house. Okay, with written proof of next highest offer being provided to the buyer herein, all parties agree to execute a conformed copy of the binding agreement reflecting the final contractual price and terms. I will go ahead and tell you that I'm going to make this recommendation to you just because there are a couple of complaints with GREC right now where a buyer submitted an offer and they were furious that the person that beat them out of the offer had a copy of their contract. Okay. I have not heard on the ruling on this yet. I'm keeping up with the realtor on it, but I haven't had a chance to talk to her about it yet. It was her buyer that filed the GREC complaint on this. If you're going to do highest and best offers, I strongly encourage you to give them a stipulation that says in there that they with the statement that they understand that because it's highest and best, that there may be escalation clauses provided in some of the contract offers. And as such, any offers can be shared with any other party once the highest offer is determined. Okay. Something along those lines. And if you need help writing one, I'm happy to do that with you. But just be aware of that because it's a very interesting dynamic about whether or not they actually can share these other contracts and whether there's going to be any issue that comes along with those and any issue that happens with those in particular. So I also want to tell you that there is a lot of discussion going on right now, and from my understanding with GREC, regarding whether or not they are going to allow escalations or they find them fundamentally abhorrent or if they find them enforceable. I'm hearing a lot of discussion right now at the GREC level as to whether or not these are going to be something that they're going to allow to continue to move forward with. Just be aware of that. This is just something that we are seeing a ton of right now. And it's something that we're having a lot of problems with on here. And one of the big issues is I have people say all the time that escalation clauses are not enforceable, but I also have people tell me all the time that escalation clauses are problematic for them as listing agents and that they don't even like them. I will also tell you that just because you have an escalation clause does not mean you're entitled to the house. Okay. There are hundreds of terms here within the GAR contract that could be a reason for a seller choosing another party. It could be because they wrote a sweet letter. It could be because they're closing quicker. It could be because they like that loan program better. It could be because they're having to pay less closing costs. They didn't really care about the sales price. They just didn't want to worry about the closing costs. It could be any number of things. And I mean any number of things that would cause a seller to choose another buyer. Please do not call me asking me to assist you with whether or not you're going to be able to push for the seller to force a seller to take your buyer's contract, because I'm not going to get into that with you. I am not going to have a conversation other than to tell you you're not going to be able to really do much on that. I'm not going to be able to get into a whole lot of that part of it with you simply because it is a problem that people think that just because they put in the highest offer, had escalation calls, which would have made them the highest offer, that they're entitled to buy a home. I will also tell you too, that one of the biggest issues that I am seeing that you guys simply are not, taking into consideration is that sellers can choose to take any offer they want. It does not have to be a cash offer with an escalation clause. It does not, especially not in multiple offer situations. So I want you to be really careful with that, and just to be, assured that just because you're telling me that you had a escalation clause, cash offer, does not mean yours was necessarily the best. Maybe you wanted to close too early. Maybe you wanted to close too far out. All of these other things are issues. Maybe, they were not able to show that you had actually seen the property yet. And they wanted to do it with somebody who had actually seen the property. Maybe they wanted a situation where they liked the FHA loan terms better than the conventional, or the VA loan terms better or less than. So just be aware that any number of issues. I typically am, and I hate to say this, but I am starting to see issues with problems with VA. More and more realtors are concerned with VA loans. The only issue I really have, because look, most VA loans go through. The only issue that I really could see is on the inspection appraisal, if they cite things that have to be repaired. The one thing about that, though, is that you are putting in your appraisal, I mean, in your financing contingency, what amount or dollar that they're agreeing to. Does that answer any of your questions about this escalation clause? Does anybody else have any other questions about the escalation clause?
I just have a couple, just two broker comments. One is there's a question about should a listing agent put in highest and best? I'll let you answer that. But you guys, in this market right now, if you're working with the buyer, every offer should be their highest and best. And with regards to the escalation clause, this is not a straight out auction like a car auction, like a foreclosure auction. It's highest and best, not just highest. And just like Amy's saying, because I get these broker calls, well, mine was more money than the others. Well, it may not have been the best other terms for that seller. So the best is the other part of highest and best. So it's a little bit tricky, and it is not a straight up auction where money is the only consideration that a seller is looking at.
And Dana, I was just looking at the calendar. I'm going to be teaching, it looks like February, possibly the GAR versus RE contract class. I think that's when it is. I was just trying to find the date. It's either February or possibly March. If you have not taken that class and you don't know the difference between the RE forms and the GAR forms, even if you have to go back and look them up and just have a basic understanding of them, I would strongly, strongly, strongly encourage you to take that class, whether it's with me or Dana or somebody else, or just take an RE class. If you don't know what the RE forms say, I would just strongly encourage you to do that. Now, Dana, what was the question you had about the RE form? I'm sorry. I was trying to find that date for you too.
Also, I'm going to look up the date. Amy is also teaching the 2021 GAR classes in December. So I'll put a link to the online calendar, and I'll point out specifically the one Amy is teaching. The question was 8-day unilateral RE forms.
Okay. So there are certain things that GAR affords you, and there's certain things that RE does not. And then there are certain things that RE does that GAR does not. GAR gives you the 8-day unilateral. RE does not give you 8 days unilateral. Here's the way that this works. It's 8-day unilateral for GAR unless it falls on, I'm trying to remember, Dana, holiday or weekend, correct?
Correct.
Correct. So you've got to know the difference between your two contracts. I have a closing right now that the buyer, who is a realtor, guys, normally works on RE forms, but she did a GAR form. Okay. She did not send over proper notice to terminate her contract. Okay. It's become a big, huge dispute. She didn't send over the normal termination, etc. Under RE, her termination would have been sufficient, except for at no time did she provide proper notice that she couldn't get her financing, which was a letter of loan denial. And we've gotten 4 of these for closings that couldn't take place on time, which are letters that basically say that the lender was unable to complete the loan process in the time given in the contract. That's not a letter of loan denial. Okay. So there's a whole lot of difference between the two contracts. There are some similarities, but a lot of it is very, very different. Dana, is there anything else on the repair issues that you want to bring up regarding RE versus GAR?
Just, you've already mentioned it. Well, I don't know if you've mentioned or not. In the RE forms contract, the entire contract survives closing.
Yes.
The problem is you guys put your buyers in a very precarious situation when you don't address the seller's lack of performance in the amendment to address concerns, because the buyer does not necessarily have termination rights, nor do they have the right to sue the seller over it once they close. If you don't put these provisions shall survive closing, or don't put options in there. And like Amy said, the buyer gets mad at you, and they're going to turn around and sue you, and it's going to be an E&O lawsuit. So just repairs are very, 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 very tricky. And definitely before you before you address repairs, the actual repairs, see if it can be handled with money just going to a vendor that can't always be used. Amy, one thing to comment on, I know in GAR, the FHA and the VA exhibits if you could just address, because I know it's in the exhibits and GAR has a special stipulation to use for conventional. What about the repairs? What if the a repair dollar amount actually turns out to be, if we have time for this, if not, there's a skip, but
I'll go over it really quickly because there's a whole lot to this. I think there's a lot to it and more time than we probably have. But in the GAR forms, if there are repairs and they exceed what the seller has agreed to, and the buyer and seller cannot come to terms within a very finite amount of time, then the contract is automatically terminated. There's an automatic termination in the GAR forms in the event that they cannot come to terms on repairs. So you could potentially lose a contract. And I had a listing agent argue this with me last week and said, the buyer doesn't get just to terminate now because we didn't agree on repairs. We only agreed to 500. They're still responsible for the balance. No, they're not. And then another one that people are getting caught on a lot is the appraisal contingency. Under the conventional, you have to send them an amendment to reduce sales price. You can't just send them over a termination of a contract based on the fact that it didn't appraise if you're doing a conventional loan. You have to send them an option and give them an option to reduce the sales price. You can't just terminate. So just be aware of some of those differences. There's a lot of them. I mean, there's a lot that goes into these forms. Dana, I think we're going to address in the 2021 GAR contract, we'll address some of those. But I will be putting together a new 2021, and it's a class that I teach on contingency forms and amendment forms. And it goes into depth of all the GAR forms that you sometimes don't really know what they all say. And it also goes into like all the weird forms that nobody ever uses. My favorite is the notification form. It's my actual favorite document in the whole set, because it is the one that allows you, when they don't do repairs, you're sending them notice. If you don't do repairs, we're terminating. If your clause says that, if they warranted something and you find out later, seller didn't, do it, or they warranted something that's not accurate, you can use a notification form. If you find out that the buyer is saying they're not going to come to closing and they don't have a right to not attend closing, you can send them a notification form that we're going to be there and we're going to take their earnest money if they don't show up. So the notification form works in a whole bunch of myriad of ways of different things. Removal of personal property and trash. This is the one that bugs me the most. I don't know why people think that they should leave their trash and their kids' belongings and all the clothes that they decided they didn't want to take with them at a property. Here's a way to address that. If you don't like the one that already has in the seller disclosure sheet that they're going to that they have 30 days to remove any personal possessions that are not supposed to be left. If they're going to, if you're concerned, or if there's a whole bunch of junk around the house, you can change that, fee of $250 per day with a 3-day minimum. You can, change all of that. You can change the amounts in there, but it just gives you a way to get them to remove this stuff and how that's going to happen. I would strongly encourage you, if they have stuff there, get a vendor over there or find a handyman really quick that can give you a quote with a video or pictures of the mess, and get a quote and go ahead and take it from the seller's proceeds at closing. Protecting your commission on new construction and buyer's agency agreement. The buyer herein purchases a lot, house, or house being used for for a new house or new construction, you agree that selling broker commission must be a part of the original offer prior to signing said offer. You're required by this agreement to provide realtor herein the opportunity to schedule an appointment to show you any new construction property prior to going to a neighborhood or contacting the listing broker or sales representative at the home site. This is really important because a lot of builders are now saying that if you don't show up the first time, that they're not going to pay you your commissions, even if you have a buyer's agency agreement. I am seeing this a lot. So it's really important that you explain to your buyer that this is to prevent any builder from attempting to pay the buyer's agency fees or the selling broker commission, so that they do not become personally obligated for payment of the commission. So if they go out and they find that home and you have sent them information, and then they go over there on their own, and you're supposed to take them on Monday, and because buyers can't wait and they're impatient and they go on Saturday and they go look at the home without you, and then the builder says, I'm not going to pay you because you didn't come and you weren't part of the showing process, then what you can do is you can still go after that buyer for your commission, but then they have to pay it out of pocket. So I'm giving you this so that you know that. Down payment assistance funds. If your buyer, say it with me, if your buyer is getting down payment assistance, and I'm very serious about this, you need to have a clause in your contract that it is subject to the down payment assistance funds. It is very important, because if they're doing a conventional loan, the conventional loan can be approved without the down payment assistance. Okay? This is very, very, very important. We had one where DeKalb County Home Buyers Assistance Program was unable to give the money for the down payment to the buyer, and the buyer had a conventional loan on there. They qualified for the conventional loan, but they didn't have the money for down payment. Lack of money for down payment is not sufficient reason to terminate a contract, and it's not sufficient reason to not be able to get a loan. Lack of down payment funds is not sufficient reason to be able to get a loan under the GAR contract. Okay. So if you know they're getting down payment assistance, you need to make it contingent upon them also getting the down payment assistance along with whatever loan program they are seeking. Sorry, I'm dropping stuff left and right. Updates to HOA letters. If transaction does not close by originally scheduled closing date due to no fault of seller, buyer shall pay for any required HOA update letters. Use that, because it is unfair that the sellers keep having to pay for update letters because your lenders are not closing on time. Okay. Listing stipulations. If the seller cancels or withdraws prior to the listing, seller agrees to pay. And y'all have this in there, but there's also early termination fees. And so if you have some of these, you can use the fee for whatever. If the property is placed under contract with a lease purchase, then they agree to pay you a certain percentage of that up front. Because none of us want to work for free. And how many of you have ever gotten a lease purchase to actually close? Very few, I know. If the listing broker procures a tenant for the property, how that's going to work. At closing, seller shall pay blank brokerage administrative fee, and then lease compensation. The other one on your special stipulations, we showed you the new construction one. The other part of this, and I would make sure that new construction one is in every single one of your contracts, as well as the lease one, because you never know when a transaction is going to turn to a lease or a new construction situation. And you want to make sure that you're paid. Okay. You want to make sure that they understand that they're going to pay you, that they have to give you the opportunity to show the property. You may want to also add in there that if there's another special stipulation I did not have a chance to add to this one that I have, and Dana, I'll send it over to you as well. And it is an agreement for viewing unlisted property or for sale by owners. It just reiterates and addresses that if you do a for sale by owner and they refuse to work with your realtor, you understand that you will solely be responsible for the buyer's agent commission. I just want you to put it out there on the front end, because so often they get mad and then they terminate their agreement with you, and then this happens. Also, your protected period needs to be completed. Don't put 0 and don't leave it blank. I would make sure you have a protected period. We actually just had a closing that got canceled. They went under contract, buyer couldn't get the loan, they terminated, whatever. And then they waited 90 days and now the seller is, I'm sorry, they waited 30 days and now the seller is doing a for sale by owner with them doing a seller financing for the buyer. And the agent found out about it and said, look, you know, I'm owed commission because I was procuring calls. Well, she didn't have a protected period in her contract. They just waited 30 days to do it just to make sure she couldn't come after them. So I want to just tell you that there are issues with those, and you want to make sure that you put it out long enough that it's going to be a problem for them to have to wait that long other than paying you. HOA, buyer and seller agree that blank shall be solely responsible for payment of all HOA dues, assessments, and you already have the closing disclosure, community association disclosure one. But here's how this works. Buyer agrees to abide by any and all rules and regulations established by the HOA, and buyer shall solely be responsible for payment of any fines or penalties assessed for non-compliance. This is when you would often use this if you have a buyer that's moving in early and the seller still owns it. If you're doing a temporary occupancy, be careful with temporary occupancies right now. We're waiting to hear what the CDC moratorium on Evictions is going to happen. What's going to happen with that? I have not heard if the federal courts have ruled on that yet. There was a lawsuit filed here in Georgia on it saying that it's unconstitutional, that homeowners are would have to hold a property because somebody else was unable to pay for it just because of this pandemic. Many of you will think, oh, but that's the kind thing to do. The problem is that you have a lot of families who depend on those rents to be able to make ends meet. I have a lot of friends who have went through divorces and taken money and put them into investment properties, and they depend on that rent every month. And there are a lot of people who are really suffering with not being able to evict people right now that are in properties that they're renting, and yet they're still having to make the mortgage payments, and now they're messing up their credit because they're not able to make the mortgage payments much longer, or have already had to stop making mortgage payments on properties because others are not paying them. Buying a property with a tenant in place who is supposed to vacate. Here is one. All parties agree that that closing date shall be on or before 10 days after seller provides legal proof that tenant has successfully evicted and been successfully evicted and removed from the property. Furthermore, it is agreed that due diligence period and financing contingency periods shall expire blank and blank respectively from the date of written notice of the same. So, there are a lot of issues where you have a tenant in place and they want to make sure the tenant's out. Here's a special stipulation for that. Agent contribution towards repairs if seller is netting zero. All this one does is says if the seller's netting zero, the realtor agrees to pay X dollars. But if at the time of closing, the seller receives funds, the agent contribution towards that is reduced by the amount of seller funds that they're going to receive. So the seller's still netting zero, but you're not having to pay for as much. We saw a lot of realtors who agreed to pay $2,000 or $3,000 for repairs to make a deal go through, and then come to find out the seller's actually walking away with $30,000. What this does is say whatever amount that they're getting is going to be reduced by whatever amount you've agreed to contribute in repairs. So if you agreed to contribute $2,000 and then you come out and they're getting 30, they're going to pay that $2,000 out of their money. You're not paying it. So if the only reason that you're paying is because you believe they're going to net zero, then you're still going to get your money. Okay. We've seen that happen a ton. Do you have any questions for me? Because we are right here at the end. So I want to make sure that you are good and you don't have any additional questions. I'm going to look on the chat too.
Also in the chat, I did post where you can get the links to the registrations for the virtual classes in December. And Amy is teaching 2021 GAR contract changes on December 16th from 10 a.m. to 1. It is virtual. We have two additional classes in December, and I know we will be teaching more in January as well. But you can be the first to know.
Let me just talk to you about this part too, because I'm getting a lot of questions about highest and best. I hate the terminology. I hate the use of it. I think it's overused in this day and age. I think it's gotten to a point where it's almost, ridiculous in the way that it's, being used. Let me just say this to you. Highest and best should be used when you have multiple offer competing situations. But here's what I would tell my buyers. If you want this home, you have to go in with your highest and best, and you have to treat it like a business. This may not be the home for you. You may love this home, but I can assure you we will eventually find you the right home for you. But you never want them to put in an offer that's going to be more than what the home is worth. Don't be surprised if you tell them, hey, it's never going to appraise. It's going to come in low, and then you're not going to have to pay that price, but you'll get the contract if you go highest. It may not. And a lot of listing agents are getting savvy to this and putting special stipulations in there just to get the deals under, that if it doesn't appraise, that your buyer agrees to pay for the difference. Okay. I want you to be really, 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 really careful about this highest and best. Highest and best really should be used only when you have competing offers, and there are multiple competing offers with similar prices and similar things, closing costs and all that, and you want to get whatever the highest and best really is for your seller. I will tell you, I also have one listing agent who told me just recently that she doesn't do highest and best unless it's just absolutely required by her seller, that she goes to her seller and says, these are your highest and best, and remember, this is what I told you your home's worth. It very well may not appraise for this. We have buyers and sellers both get upset when they put in an offer for way high because they've been told it would never appraise, then it does, or they put in the seller in the alternative, they get an offer that's super high and then it doesn't appraise, and they end up, because of that appraisal, getting less than what they possibly could have had they accepted the highest offer they got before they went for highest and best. We've actually seen this happen where they went with the highest and best offer. It didn't appraise. That loan fell through. They went back to the next backup. They ended up going under contract. And that next appraisal actually was what the first offer that the person that didn't get the home had agreed to. It was like $2,500 higher than the list price. Instead, they took the $10,000 higher than list price, and then it didn't appraise, and they wasted time and energy. So I just want to just caution you about getting too far out there with your buyers or sellers. If the buyer is insistent upon putting in for way over, I want you to follow up with them in writing saying that if it does not appraise, you may not be able to get this home if it doesn't appraise. But then you also may have a situation where if it does appraise, you may be paying more than the home is worth based on the highest comps in this neighborhood. Alternatively, one other thing I want to point out to you guys is selling new construction. A lot of the contracts now have language in there that the realtors are not allowed to be present for selections of options. Before they go, I want you to do an analysis of the neighborhood and tell them, I'm not allowed to come with you for the selection of your options. Please keep in mind that the median price home in this neighborhood is X. The highest priced home sold in your neighborhood in this phase is X. We've had a lot of buyers go under contract and then go to do their options upgrades, and in many cases end up $20,000 and some as high as $60,000 more than the highest priced home sold in that neighborhood. You never want your buyer to be in that position. So please prepare them before they go, because that's why the builders don't want you there. They don't want you trying to downsell their options upgrades, because they make a lot of money on that. Okay. And they don't really care if it appraises or not, because guess why? Or not on the options upgrade. So please be cautious of that. Do you have any other questions for me? I don't see any questions. I see a lot of you signing out. If you have questions for me, go ahead and put them in there, or turn your mute off and ask. Dana has already submitted on the thing where you can reach, where you can get the forms for. She put a link on the chat, so you have to scroll back through the chat to get that. Also, really quickly,
there was one question about, as a buyer's agent representing a buyer, when there is a call from a listing agent as highest and best, there's always the concern that their offer was not presented to the listing agent. I mean, not presented to the actual seller. So what are your comments about?
Yeah, there's a couple of things you can do. So there's a couple of things, like I love the notification form, because you can send it over and ask that the seller initial off on it, saying that the seller is in receipt of buyer's initial offer dated XYZ and the amount of whatever it is, to certify that the seller actually received it. We use this one a lot when we have situations where we think that the listing agent is not presenting something. Guys, if you call a listing agent and say, look, we need some repairs done, and they immediately say, my buyer isn't going to do that, send it over. And then if they say, look, I told you my buyer's not going to do it, send over a notification that buyer has submitted on the notification form, and it can say something very simple. Buyer has submitted a request for amendment to address concerns, and on blank date with the blank amount, and put the information on that notification. And that seller is seller is refusing to do any of the requested repairs. Put it on that notification. We've sent that out multiple times, and done that with our clients who feel like a listing agent is presenting an amendment to address concerns. And so often, within a few minutes of sending that notification, they get the signed amendment to address concerns back, but they never get that notification form back. So we have seen where they're not presenting those requests for repairs. I actually saw it bite a listing agent in the rear in my office really badly one day, because the buyers were extremely upset that sellers wouldn't do some pretty significant repairs. And they had an email from the listing agent that, yeah, all of that sounded good. My seller will do all of that. Then they sent everything over, and the seller refused to do it. They got into a bind where they needed to get sold. I need to get a home purchased because they were doing a sale that was already under contract. So they got nervous, went in and agreed to it. But when they got to closing, they addressed it with the seller and said, I don't think it was right that you did the bait and switch. I don't think it was right. And the seller said, we never got a request to do any repairs. in my closing room at my table. If y'all want to talk about feeling very uncomfortable, I was very uncomfortable with that situation because I knew that they had not presented all offers at that point. And the listing agent said, I think this is an inappropriate time to have this conversation, and got up and walked out. So I want you to be aware that these they do happen. I'm sorry it happens. It's unfortunate that it happens, but if you're in doubt, use your notification form to send out to them and say, we've sent it to, and we want to make sure, and we want to confirm that you've actually received it and reviewed it and that you're not agreeing to do those things. Okay. So there's lots of fun things you can use the notification form for.
Amy, I'm not seeing a link. Dana, am I missing that?
You
the
have to
link?
scroll up in the chat. She put
I
it
just
on
posted.
there.
I just
somewhere.
reposted it again.
Thank you.
You're welcome.
Yeah, so if you go to the eAgent web and click on training videos, it's in there.
They're not there
Thank
Hannah
yet.
you.
Spiller asked agent to put a focus rule. Even if the offer was. If they have the funds to come to closing with, yes, that can happen. We are seeing a lot of that, where they are doing a highest and best. They're going above the list price and then putting in there that this buyer, if it doesn't appraise, the buyer has to come to closing with the additional funds. Yeah, it can happen. So just be aware that that can, be an enforceable requirement. Okay, Dana, we are at the very end of it. Is everything good? Do you need anything else?
I'm going to take the host back so I can finish
Good.
up the poll. And thank you guys so much. Again, I'm going to post a link to the special stipulations in just a minute. The video will be available next week. Amy, thank you so much. Thank you guys, everybody. 3 to 5 business days for the CE credits. And we appreciate everything. Lots of people out there need your help. Go
Thank
help
you.
them. Awesome.